So everybody is ready. See, we will be starting from 9:30 now.
Yes, sir. We'll start from 9:30, sir.
And what about the technical support team? Did you people
Sir,
contacted him?
yes, sir. We've contacted him, and Ramesh sir is here, sir.
Okay, okay, okay. Good morning, sir.
Good morning. Good morning.
Good morning.
Good morning, sir. Sandeep, sir. Good morning.
Good morning. Morning to all.
कितने लोग हैं? Good morning, everyone. Good morning, Sandeep.
Good morning. Good morning.
Good morning, sir.
Good morning, everyone.
Good morning.
A very good morning to everyone.
Good morning.
Good morning.
I'd like to welcome everyone to the one-day international seminar on privatization of space sector in India, issues and challenges. We are extremely obliged to have you all amongst us virtually. I'd like to welcome the Director of Symbiosis Law School, Hyderabad, Professor Dr. Sarfraz Ahmad Khan, for the welcome address.
Thank you, Akshara. Am I audible?
Yeah.
Okay. Respected Professor Dr. Sandeepa Bhatt, Professor Dr. Ricky J. Lee, Mr. Hamza Hamid, Professor Dr. Attila Sipos, Dr. Thomas Blackzers, Professor Dr. Balakrishna Reddy, Professor Dr. Christopher Newman. I can see there are other known faces who joined there, Dr. Sheikh Nazim Ahmad. All participants, all the members of the center's audience. Today, on behalf of Center for Aerospace Law and Symbiosis Law School, Hyderabad, we welcome you all to this seminar on the topic privatization of space sector in India, issues and challenges. I would like to thank our honorable speaker for taking the time out from their busy schedule to address young minds. We are thankful to Professor Dr. Sandeepa Bhatt for coordinations and support that has helped the center to carry out this today's session. In Symbiosis Law School, Hyderabad, we prepare our budding lawyers to face such challenges that the dynamic legal fields places before them as an opportunity to find solutions that can protect these persons in need, value their right, protect the country socially, economy, and culturally, providing them with the most relevant academic and practical knowledge on a subject of relevant domestically as well as internationally, and to give them experience through experts so that they can pave a path for their own success academically or in any other field, achieving more from beyond the classroom learning per platforms such as this webinar, developing from further or conferences or seminar. We are proud that Symbiosis Law School Hyderabad consistently developing this culture of organizing seminar conferences to increase the legal literature and contribute as whatever is possible from our side. So in last academic year, before this pandemic, we had almost 9 national international seminar and conferences. Due to pandemic, we have decreased, but we from long time we are planning for this conference, and few of active people has made lots of contributions in making this conference successful. At the speaker present today have one thing in common, which brings their dedications as well as discipline to get where they are in their professional life. With the discussions that the theme will facilitate, they will be able to share visions and paths which choose to follow, overcoming professionals and other personal hardships to become one of the most reputed and well-decorated individuals in the field of air and space law globally. They will provide all of you the glimpse into the different perspective in this field of study, and we hope that this discussion will also enlighten you as the indispensable skills required in these professions, including leaderships and crisis management, when studying and debating matters for such national and international importance. This is the very first time that an event happening at such level where people in these pandemic situations where people from almost all the continent of the globe joining us for these conferences, and the time zones are different. So where such a great eminent personalities are gracing our events, I hope that the event can prove be to huge success and of value to all of you. These programs, we want to preserve this memory, and we want to develop some literatures which can ultimately contribute in the entire debate on the privatizations of space. So the space law is a area which developed, but still is lots of things which supposed to be done at the national level as well as international level. So hope this conference will contribute in those directions, that the outcome of this conference or the papers which will be presented, or ultimately we have planned to publish edited volumes that will enormously contribute in the literature on the space law. So with these few words, I welcome all the participants and the speakers, honorable speakers from the different parts of the world. And again, I not only welcome, I thanks Dr. Sandeep Bhatt, who was the persons behind organizing these programs, with whom we are contacting and coordinating from quite long time to make from our planning stage to make it successful today. So hope with lots of enthusiasm, the centers has organizing these programs, and conference may be over in one day time, but the things which we are carrying forward, the academic deliberations, literature development, the goals which we have fixed, this will continue. And again, I need support of all the resource persons who joined this conference from different part of the world, as well as all the other participants, that let this center which we have established at the Symbiosis LawSchool Hyderabad will act as one of the think tank on the issue of space law. And we need your, not only for this conference, but we need your constant support throughout the in coming days. And I wish we can get the same kind of support with all of you. With these few words, I once again welcome you all and hope you enjoy the conference. I hereby convey to best wishes to all the participants and the organizers. So thank you everyone. Yeah.
Thank you so much, sir. Now we have Professor Dr. Sandeepa Bhatt for the keynote speech. He's working as a professor of law and director of Center for Aviation and Space Laws at National University of Juridical Sciences, Kolkata. Dr. Bhatt has published more than 45 articles in the journals of international and national repute. He has presented more than 90 research papers in international and national conferences. Sir, please.
Yeah, thank you. I think first of all, actually, you have got a quite old photograph of mine in the university website, maybe it's 15 years back, maybe more or a little more than that. Okay, right.
They want to keep you young always.
Okay. Yeah, I'm young still by heart, so I should actually acknowledge it. Right. So can I share the screen? I think somebody shared the screen already, so I have a small PPT,
Yes, sir.
so I'll just share the screen. think there's some problem. Check once again.
We can see the screen right.
Okay. Right. I hope that I'm also audible.
Yes, sir. You're audible.
Good morning to all of you. And I should also say good afternoon and good evening to some of my friends, the resource persons who have joined from other parts of the world as well. I should thank them first for actually honoring my invitation and being part of this conference. So thank you so much for all the resource persons who have joined from different parts of the world. I am also having the privilege of sharing this inaugural session with Professor Ricky Lee, one of the eminent figures, eminent personalities in the field of space law. Coming to my topic, since actually today's discussion is on the privatization of the space sector in India, I thought of speaking on whether we are legally ready for the privatization of the Indian space sector. So how far we are ready for that? As a backdrop, let me tell you that the Indian space sector has been predominantly a state-oriented space sector. Over the last more than, say, 4 to 5 decades, it has been the Indian Space Research Organization, which was the sole player in terms of the space activities. It was nothing but actually the government-run space activities. There was no scope for the privatization. Of course, an attempt was made in 1992 by establishing a body called as Anthrax Corporation. Of course, it's a very limited attempt. I'm not saying that actually it's a full-fledged effort for the purpose of privatization of all space activities in India. It is just to commercialize the ISRO's space application. So a kind of a commercial arm was basically established in the form of Anthrax Corporation. To a limited extent, Anthrax Corporation has been successful. Some private companies have started up. Of course, they are also involved only in some peripheral space activities, not the direct space activities like launching or maybe controlling directly. All those kind of activities have not predominantly started in India. As all of us know, during COVID-19, almost all the parts of the world have been heavily affected in terms of their economy. India is one of those countries, of course, has been affected enormously in terms of the economic problems. And there have been plans for the purpose of coming out of the economic problems and to boost the Indian economy. One of the plans which has been put forward by the Prime Minister has been to go for the privatization of the Indian space sector. When we mean privatization at present, it is not just commercializing the ISRO's space applications, but also to go for even the private players to establish the launch facilities, carrying on the launch operations, and also even actually receiving the signals and so on and so forth. So all kinds of the space activities are contemplated under the current plan. And already proposal has been made and even the draft has been prepared for the purpose of establishing the IN space, that is the Indian National Space Promotion and Authorization Center. Right, so there is a center which is going to be established for the purpose of permitting and overseeing the private space activities in India. And this proposal includes multiple aspects like the sharing of the facilities, whatever ISRO facilities are there for the purpose of launching or any other kind of the space related applications, they would be shared with the private players. There would also be possibility of establishing the new facilities by the private players in the Department of Space premises. They can also go ahead with the establishment of their own launch facilities. There would also be provisions for monitoring the space activities by the private players. And even there is also another link in terms of the ISRO industry interface. That's primarily to, again, continue with the commercialization of ISRO's application. So ISRO would be willing to help the private players if at all they are intending to take the services from the ISRO for carrying on their space activities. So these are the major plans which have been done at present for the purpose of the privatization of the space activity. Now, does this mean that India is going to become a safe haven for the private space players? Is it that we will be having more and more private space activities in the course of time, especially because maybe the cost of launching and operation in India is comparatively less when compared to that of most of the countries. So precisely because of that reason, is it that India is going to become a hub of the private space players? I should say, hold on. Hold on. Where is the law? Where is the law for the regulation? We have already committed in the international level in different space treaties certain kind of actually the obligations. We are parties to the Outer Space Treaty, Rescue Agreement, Liability Convention, and also Registration Convention. Though we have signed the Moon Agreement, we did not actually ratify that. So out of the 5 major treaties governing the space activities in the international level, we are parties to the 4 major treaties. There are obligations under the treaties, which we need to implement. We cannot bypass those obligations while carrying on while authorizing the private space activities. So we have to be permitting the private space activities within the 4 corners of the obligations, whatever we have undertaken under the international space treaties. Now, what are those key obligations which require supplementing in the municipal level so that the private space activities can be properly regulated? Let me highlight upon these key issues. I'm not saying that these are the only issues. What I'm saying is that these are the major issues which require the proper regulation before we start the private space activities. First is the question on responsibility and liability. If we look into the space treaties, Outer Space Treaty has a provision under Article 6, which says that appropriate state party to the treaty shall be responsible for every space activity, whether it is carried on by the public entity or by the private players. So for all of them, the state is responsible, the state is responsible. And there is also a requirement of authorization and continued supervision of the space activities by the concerned state. Then as far as the liability is concerned, we have Article 7 of the Outer Space Treaty, which has been supplemented by the Liability Convention 1972. There's a separate convention also in terms of the liability for the damage caused by the space activities. Interestingly, both the Outer Space Treaty and the Liability Convention speak about the liability of the launching states. They don't mention about the liability of the private players anyway. Of course, it's understandable because it was 1960s and 1970s. During that particular period of time, only the states were the primary players in the space activities. Therefore, these laws or these international treaties are entered in light of regulating the state-oriented space activities, not the private sector-oriented space activities. Right? So therefore, it speaks only about the liability of launching states. And the definition of the launching state is wide enough to encompass any launch, whether it is by the state or by the private player. Because you have, say, a state which actually launches the satellite, state which procures the launching of the satellite, state whose territory has been used, and state whose facility has been used. All 4 different categories of the states do come within the ambit of the definition of launching state. And all of them are jointly and severally liable. In case of any damage, they're jointly and severally liable. So even if a private player is launching from India, at least by virtue of allowing its facility or the territory for the purpose of the launch, it would come within the ambit of the definition of launching state. So in both in terms of responsibility and liability, we can find that the state would come into the picture and there is no mention about the private players as such. So that is why we have to find out, suppose if the private players are going to carry on activities extensively in India, what should be the extent of responsibility for India as a state? What should be the liability for any damage caused by the space activities by all these private players? All these things need to be properly assessed, and we have to make proper arrangement for the purpose of ensuring that there is some kind of cushioning of the liability, either by the private players or through the insurance mechanism. If we look into the other countries' models, they've already come up with maybe some of them in terms of the liability sharing arrangement, and almost all of them in terms of a compulsory space insurance. They will insist for actually insurance coverage. So in case of any damage caused by the space activities, insurance companies will be coming for the purpose of payment of compensation. So that's how they have worked out the liability sharing as well as the space insurance in most of the countries. But in India, we might have to think a little more reflectively. because liability sharing and space insurance, both of them might have their own limitations. Liability sharing, how much of the liability a developing state like India can share with the private players, that's really debatable. How much can be cushioned by the state is really debatable. Space insurance, in a circumstance wherein the insurance company becomes bankrupt by virtue of catastrophic damage, then the liability under the liability convention would still exist. The victim state would claim compensation under the liability convention, and India as a state would be liable to pay compensation. As a launching state, it would be liable to pay the compensation. So therefore, even the space insurance might not work effectively in a country like India. So what I propose is that we have to think in terms of establishing a space fund, maybe through the contribution by like the private players or maybe the public entity, whatsoever it may be. All of them may contribute a certain percentage of the profit, whatever they have made, to create this space fund, which would help in terms of actually paying the compensation in case of any damage being caused out of the space activities. And this has been effectively worked out in the nuclear liability regime. We can find that many countries have already created a civil nuclear liability fund. So similar kind of a mechanism might be required in India to deal with the aspect of the liability. Second major issue is in terms of the property right. If we look into Article 2 of the Outer Space Treaty, it clearly says that outer space, including the moon and other celestial bodies, is not subject to the national appropriation by claim of sovereignty, use or occupation, or by any other means. And it reflects the sentiment of the common rights regime, whatever has been advocated by the drafters of the space treaties. If we go back to the 20th century development in terms of the space treaties, they have advocated for the common rights of everyone. Even though Article 2 speaks about national appropriation, it in turn also prohibits the individual appropriation. Private players also cannot actually claim property rights. It is absurd to argue that the states cannot claim any rights over the outer space and celestial bodies, but private players can claim the rights. So it's an absurd argument. And unfortunately, there are many people who are already claiming certain rights over the outer space and celestial bodies. We have people like Dennis Hope, Sylvia Langevin, who have all actually claimed the different celestial bodies. So in order to ensure that such a kind of activity would not happen in India, we have to have the proper clause or proper regulation in the national space legislation. We should not allow such kind of things, because allowing such a kind of a business or such a kind of an activity would be contrary to that of Article 6 of the Outer Space Treaty, and India as a state would also incur responsibility for the failure to regulate these kind of activities. Next, third aspect, I should say we need to regulate space tourism. Space tourism is going to be in all probability, the next generation fascination. Already, many private players have developed their technology, so they are about to actually launch, they are about to actually start this business of the space tourism. It might enter into the Indian sphere, especially because of, as I have already pointed out, the cost effectiveness. So primarily because of that reason, we might have actually the extensive space tourism activities. Operators may start carrying on the activities from India. But this also poses multiple questions. Questions with respect to activities of the tourists in the outer space. If they commit a wrong, if they commit a crime in the outer space, how to exercise the jurisdiction over them? What kind of law should be made applicable? Then, in case of an emergency landing of the space tourist, what are the obligations of the other states wherever the emergency landing happens? Even though we have a rescue agreement of 1968, the rescue agreement speaks about only astronauts and personnel. It speaks about the protection and the return of the astronauts and the personnel. It doesn't mention about the protection of the tourist per se. So the question is whether the space tourists do come within the ambit of the definition of astronauts and the personnel, are they entitled to the protection under the rescue agreement? I believe no, they would not be coming exactly under the protection, because the rescue agreement is a logical extension of Article 5 of the Outer Space Treaty, which says that the astronauts are the envoys of the mankind. They are the representatives of the mankind, especially because they'll be carrying on certain activities in outer space for the benefit of the mankind. But space tourists are not going for that. They're going for their personal enjoyment, applicability to the rescue agreement is also debatable. So in order to properly regulate, and even another important problem in terms of space tourism is that who is going to authorize and who is going to continuously supervise the space tourist activities? Is it India because operation is taking place in India? Is it some other country to which the operator belongs? Is it any other country to which the space tourist belongs? So which country would be actually having the duty to authorize and continuously supervise the space tourism activities is something which is really debatable. Therefore, it need to be clarified in the Indian regulation. Next aspect is the protection of space environment. Outer space environment is very fragile. And if you look into the current statistics, the picture, or maybe actually the existence of the debris in the low Earth orbit and in the medium Earth orbit brings in a kind of a very, very scary scenario. There are a lot of debris in the lower Earth as well as the medium Earth orbit. This debris would be a major threat for even carrying on our future space activities, because they move with a very, very high velocity, and any object which would come in the way of the space debris would be destroyed completely by the debris. So precisely because of that reason, we have to cater to the space environment while carrying on the space activities. And it has to be carried on in a sustained way. We have a provision under Article 9 of the Outer Space Treaty, which says that while carrying on activities, there shall not be any harmful contamination of the outer space and adverse changes in the Earth environment. That's what it basically speaks of. And it also says that states need to take appropriate measures for the purpose of ensuring that any actor, maybe the state actor or the private players, would not be harmfully contaminating the outer space. So that has to be implemented in the municipal level by categorically mentioning in the national legislation. Significant aspect is about the military activities. Space activities started in 1957, primarily for the purpose of taking military advantage. Whatever may be the argument which has been put forward, both US and USSR were interested in using the space technology for the military purposes. Because that was the time of the Cold War, right? Cold War era, and they wanted to outweigh each other in every sector and wanted to have some military advantage. And it was understood by the international community. You can see that in the series of UN General Assembly resolutions, as well as subsequently in the Outer Space Treaty, there has been a mention about the requirement of peaceful uses of outer space and celestial bodies. Article 4 of the Outer Space Treaty primarily speaks about it. Of course, there are many loopholes in Article 4. I'm not going to discuss that because this is not the platform to discuss on Article 4 of the Outer Space Treaty. What I can tell you is that Article 4, to a limited extent, speaks about the de-weaponization and demilitarization of the outer space and celestial bodies. Right? So it speaks about that. But as I told, space treaties obligations are mentioned only on the states. And whenever the state is authorizing the private players to carry on the space activities, it should ensure that even the private players are not going to violate these provisions. So militarization by the private players should be prevented, and it should be ensured that outer space would be used for the beneficial, peaceful users rather than the military activities, which might result in hostility and ultimately threaten the international peace and security itself. Next aspect is about the IP issues. All of you must be aware of the fact that there are inventions which are going on in the outer space. International Space Station project, or maybe other kind of the stations, the proposal for them, all of them are primarily for the purpose of carrying on inventions in outer space. This is because outer space atmosphere is conducive for carrying on certain kind of inventions, especially near zero gravity available in the outer space. That would be useful for pharmaceutical inventions. Different kind of the pharmaceutical products can be actually invented because there would be greater purity in terms of the compounds which may be created. So that's why inventions are going to take place extensively in the outer space or maybe in the celestial bodies in the future. Questions which would crop up regarding these inventions would be, can there be patent rights to be granted? Patenting. Why am I saying this? I'm saying this because the patent law is primarily dependent on the monopoly right logic, But whereas the space law, as I have already pointed out, is advocated on the basis of the common rights principles. Monopoly rights versus the common rights. So you use actually certain things in the outer space or maybe in the celestial bodies, you produce something, can you get a monopoly right on the product? Especially if you go for a product patent. So can you get a monopoly right on that? You use the common resource for the purpose of actually creating this. So therefore, there are debates about the conferment of the patent rights, especially in terms of the product patents. There are also problems in the circumstances wherein an earthly patent has been infringed in the outer space. So what law has to be made applicable? We don't have the international patent law. So what law has to be made applicable and who has the jurisdiction? All these issues are debatable regarding the IP laws. Finally, I should say about the financing of the private space activity. Whenever we speak about the private space activity, unless and until there is a financing, it is not going to kickstart. Space activities would involve multi-billion dollars investment. That would be huge investment. You need finances from different jurisdictions. Single jurisdiction finances might not be able to support you to the extent of multi-billion dollars. Unless and until every creditor is ensured of the fact that they will get back their investment from the debtor, nobody is going to invest in the sector. Right? Nobody is going to invest in the sector. So they have to be confident about the return of their investment. And our municipal laws are varied in different jurisdictions. Consequently, there will be a lot of confusion and chaos which will be created out of it. We need harmonization. In fact, Unidruva has tried to harmonize the private laws on the financing sector. They basically looked into the mobile equipments, which also includes the space asset. So they have come up with a convention and also a draft space protocol. Unfortunately, that has not been actually entered into force. The system has not entered into force. It has also been rejected by the financiers to a greater extent. So precisely because of that reason, we have to cater to this in the municipal level so that we will ensure that sufficient investments should take place in the private space activities. So therefore, in my concluding remark, I should tell you that the privatization may be essential. I'm not against the privatization, right? So all these things are not supposed to be construed as I'm opposing the privatization. Privatization may be essential for the purpose of boosting our economy, but to ensure that we are also going to respect our international commitments under the space treaties. We are not actually commercializing by compromising our obligations under the international space treaties. And for this purpose, the law should precede the practical aspect of commercialization. Right? If we go for commercialization now and think in terms of the development of law subsequently, it is going to be a futile exercise. It is not possible to regulate it properly. And I should also say before concluding that India is law. Since 2001, there have been actually multiple attempts which have been made. And in 2017, there is also a draft space legislation which has been prepared and open for the public comment. However, there are a lot of loopholes. There are a lot of loopholes in the draft space bill. I think there are some presentations which are going to be done on the draft space bill also in today's session. So let me not delve into it in detail right now. Let me tell you in my final observation that we should have the law first, and then only we should go ahead with the privatization of the space activities. That's all. Thank you.
Thank you so much, sir. And now I'd like to welcome our chief guest, Professor Dr. Ricky J. Lee. He is adjunct professor of law at University of Notre Dame, Australia. He is one of the world's leading experts in space law, having acted for launch operators, satellite operators, regulatory agencies, and government entities around the world. He has been in legal practice for 2 decades and admitted to practice in Australia and New Zealand. He has published over 120 books, chapters, articles, and seminar papers to his name on space law, international law, and commercial law. It's truly an honor to have you amongst us. Sir, please.
Thank you very much for that kind introduction. Are you able to all hear me?
Yes, sir.
Yes, sir, we can.
Excellent. I'm just going to fire up my presentation. While I'm doing that, I would just like to say, Professor Bhatt, Professor Khan, and Professor Kumar, thank you very much for your kind invitation. I'm truly humbled to join with the three of you in this inaugural session of this conference. And the topic that I would like to speak on, is my presentation now up and running?
Yes, it is.
Excellent. The topic that I've chosen to speak on is to talk about the Moon Agreement. I'm grateful to Professor Bhatt for his very comprehensive and informative presentation on the legal issues arising from privatization based on the 4 United Nations space treaties that India is a party to. What I wish to do is to spend a little bit of time focusing on the one treaty that India is not a party to and the commercial and practical implications of that, particularly with the prospect of space mining that may arise in the next few decades to come. So, just as an overview of what I propose to talk about, I want to first of all give a short overview as to the prospects of mining in space. Why would we go mine in space and what is there to mine for us? Then I want to run through very quickly the basic tenets of the Moon Agreement and the current controversies in relation to the Moon Agreement. India's status as a signatory rather than a party of the Moon Agreement, and also to talk about some very recent developments in the field of space mining and the regulation of space mining in the form of the Artemis Accords that have been negotiated between the United States and 6 other countries just in the last few months, and what I would suggest would be the next steps for India going forward if India is to play a prominent role in future either governmental or private space mining. So to give a brief overview as to why we should mine in space, there are 2 concepts that we need to grapple with. The first is resource scarcity. From a very young age, I have read about how there are predictions as to when we will run out of mineral resources on Earth that we currently consume. For example, we were supposed to run out of petroleum in another 30 years' time. We're supposed to run out of coal in 60 years' time. We're supposed to run out of natural gas in 80 years' time. But more importantly, also with minerals and metals, we're supposed to run out of aluminium in about 70 years' time. We're supposed to run out of iron in about 120 years' time. These predictions are based on the concept of absolute scarcity. It's based on the idea of, well, how much of these minerals are we currently using? And what do we estimate are the resources that are available in the Earth's crust that we can actually extract and be able to use? The problem with the idea of absolute scarcity is that they are always preceded by economic scarcity, which is the second concept that we have to grapple with. Economic scarcity arises where it is simply not worthwhile to extract certain minerals from certain mines. There are certain factors that may arise, that may cause this to arise. The first is that the quality of the mine may not be sufficiently rich for that to happen. Secondly, the environmental damage may be too substantial. Thirdly, it may be located at a place that was simply too hard to get to. As an example of how economic scarcity may arise, 120 years ago, in order to extract a single ounce of platinum, one would process about half a ton of ore in order to extract that 1 ounce. Today, 120 years later, to extract 1 ounce of platinum, it now takes on average about 5 tons of ore to be processed. The quality of mineral ores are declining just as much as the accessibility of these mineral reserves on Earth are getting harder, both in terms of practical sense and also in an environmental sense. the good thing for humanity as a whole is that many of these mineral resources are available in some abundance in space, particularly on asteroids. And it is recognizing this, that there are quite a few enterprises such as Alphabet, which is the holding company of Google, and also some governments that don't intrinsically have a space industry of their own, have recognized the potential of space mining and want to get ahead of other countries and other businesses in being able to access the abundances of space resources. Well, as Professor Bhatt suggests, the law should precede the practice. So one attempt on the part of the international community to provide the legal basis for space mining came about in the Moon Agreement. It is the last of the 5 United Nations space treaties. It was finalized in 1979, and it entered into force in 1984. It has been ratified by only 18 state parties. By comparison, the Outer Space Treaty is ratified by over 120 countries, but only 18 has ratified the Moon Agreement. And I apologize for the abbreviations. They were supposed to be flags, but when they transposed to PowerPoint, obviously the flags didn't go with it. For that, I apologize. Apparently emojis are not as universal as one may think. But just to run them through very quickly is Armenia, Australia, Austria, Belgium, Chile, Kazakhstan, Kuwait, Lebanon, Mexico, Morocco, the Netherlands, Pakistan, the Philippines, Saudi Arabia, Turkey, Uruguay, and Venezuela. One common thread you would probably observe about these countries I've just listed is that most of them don't have a mature space capability. Arguably, Kazakhstan has a mature space capability, but that's very much transplanted from Russia, from the Soviet days. Australia may be said to have some space capability, but Australia doesn't launch its own space objects. They launch it overseas, though Australia do have a significant fleet of satellites. The other countries are at varying stages of advancement in terms of space industry, but none of them are certainly to the scale of maturity and scale that India has achieved in its space sector. There are 4 states that have signed it but not ratified the Moon Agreement, and they are France, Guatemala, India, and Romania, of which, as you no doubt would observe, only France and India are mature space powers. So among the field of states that have either signed or ratified the Moon Agreement, India is in a unique position where it has a significant, mature, and well-developed space sector. But unlike most of the Western countries and industrialized countries that chose not to participate in the Moon Agreement, it is also a very commercialized sector, though it is very much dominated by government and public needs. The most important part of the Moon Agreement, and also the most controversial part of the Moon Agreement, is Article 11. And Article 11 designates space resources as a common heritage of mankind. And it foreshadows, it doesn't create, but it foreshadows a regime whereby there would be some sharing of the benefits that may be derived from the use of space resources. During the negotiations over the Moon Agreement, the industrialized countries and the developing countries could not agree as to the content, the substance of what benefits are going to be shared and how much of those benefits are going to be shared. In 1978, it was India that proposed a compromise. It was that we will put off the creation of the regime and therefore the determination of how the benefits from space resources are to be shared into a future point in time. In the meantime, there would be no moratorium on countries doing mining activities. That compromise ultimately became embodied in the Moon Agreement that was adopted in 1979. So there is a future regime that is supposed to be created where there will be some sharing of resources as either a percentage or some kind of benefit, some other practical benefit, or maybe the commodities themselves that may need to be shared. But in the meantime, you can do whatever you want because there is no moratorium in space mining until that regime is created. Now, speaking of India's position as a signatory, Article 18 of the Vienna Convention of the Law Treaty says a state has to, in effect, follow or not do anything that runs against the object and the purpose of a treaty that they have signed, unless and until they say, oh, we're not going to ratify it. We signed it, we thought about ratifying it, but we decided not to do it. India hasn't done that second step. It's only done the first step, which is that it has signed a treaty, but it had not indicated whether it would or would not ratify it. It's important to note, just for the sake of completeness, that India hadn't signed or ratified the Vienna Convention on the Law of Treaties. So while I refer to Article 18 of the Vienna Convention, I do so because Article 18 reflects binding customary international law, not because it is a treaty that India is party to. Getting back to space law now, one of the recent developments that had happened in October 2020 is that there were negotiations between the space agencies in the United States and 5 other countries that resulted in the signing of the Artemis Accords. And the Artemis Accords, of which Australia is a party, along with Canada, Italy, Japan, Luxembourg, the United Arab Emirates, the United Kingdom, and of course with the United States, they set out some fundamental rules as to how they are going to regulate or protect, more like, their activities on the moon, on Mars, and other celestial bodies such as asteroids. And part of that involves protecting private industry as well as governments in mining activities, and also protecting their revenue and their profits from being able to sell off the minerals that they extract from outer space. These rules and regulations that they have negotiated and agreed between them are based on the freedom in Article 1 of the Outer Space Treaty, so no reference to the Moon Agreement, in relation to the freedom to use outer space and its celestial bodies for themselves. Of the 6, now 7, because Ukraine has since signed on to the Artemis Accords, of the 7 countries that have signed them, only Australia is a party to the Moon Agreement. India is not a signatory to the Artemis Accords, and as far as I'm aware, there are no imminent move on the part of either India or the United States for India to sign on to the Artemis Accords. And I was privileged in last year to have some involvement in advising the Australian government in relation to the Artemis Accords. And I would suspect that there are elements of the Artemis Accords that would be unpalatable to India. So in terms of privatizing the space mining sector or the future space mining sector and the role that India can play, there are ultimately 3 things that India can do as a nation to take advantage of this potential area of space, leveraging India's current scale of development and involvement in the space sector. The first is, as I suggested in the previous slide, to seek to negotiate with the US and accede to the Artemis Accords, as Ukraine has done. Secondly, it can choose to ratify the Moon Agreement and then call a review conference under the Moon Agreement to start negotiating that foreshadowed regime. At least start to move the international community towards embodying the Moon Agreement and creating an international regulatory framework that is not just limited to the United States and their friends. Thirdly, it can legislate on private or some hybrid being government and private space resource ventures to provide a competitive regime as compared to other countries where there might be advantages in relation to insurance, there might be advantages in relation to regulation, advantages in relation to insurance indemnity that may attract space mining ventures to be based in India and be funded by other developing countries or by Indian sources, and in fact steal a march on the Western enterprises that are seeking also to extract resources from asteroids and either bring them back to Earth or to use them in space. I hope in the last 15 minutes or so, I've given you a, I hope, informative snapshot of the Moon Agreement to supplement what Professor Bhatt has done in relation to the other major issues to do with privatization. Before I finish, can I say just as a can I just say to I'm certainly emboldened to see so many students and young scholars who are participating at this conference. 23 years ago, when I finished law school, space law as a subject didn't exist. And in the last 23 years, despite never having studied space law, I have advised governments, I have advised launch operators, I've advised satellite operators in space law, a topic I never in fact studied. The message I want to say to you is that in a world where there are far more lawyers than the rest of the world would like to see, if you have ambition in space law, if you have a strong interest in space law, then by all means pursue it, because the opportunities that can come from hard work and dedication is probably more prevalent in a field like space law, which is emerging, than other areas of established areas of international law or industry sectors where you may have been taught and been involved in. There are opportunities that are arising now and plenty of opportunities that will arise in the next 10, 20 years to come. And so if it is what you want to do, if it is what you're interested in, don't let other people say to you, oh yeah, it's a very small, obscure field that only 2 or 3 people get to do it. Well, I can tell you, at least on my own example, that that's not true. Thank you very much.
Thank you so much, sir, for the insights. And now I'd like to welcome Dr. Shailendra Kumar, faculty in charge for Aerospace Law Symbiosis Law School, Hyderabad. Sir is currently working as an assistant professor. Previously, he has worked as a research assistant and research investigator in government-sponsored research projects at the West Bengal National University of Juridical Sciences, Kolkata, and National Law School of India, University, Bengaluru. Sir has always been interested in social legal research, legal writing, aviation law, space law, and international law. Sir, please.
Oh, sorry. I'm very sorry. Actually, my like this like the mic was mute. Sorry. Good morning, everyone. I take immense pleasure in being part of this event that has been organized by Center for Aerospace Law at Symbiosis Law School, Hyderabad, in association with Law Mantra and International Council of Jurists. Today's festive have been kick-started by Dr. Sarfaraz Ahmad Khan, Director of Symbiosis Law School of Hyderabad, Dr. Sandeepa Bhatt, Dr. Ricky Lee. The insight that has been received in last hour is indispensable and has led a correct foundation in continuing the proceeding of today upcoming event. Okay. Uh, Proceeding today upcoming event, while it would have been an honor to physically welcome all of you at campus, the protocol that have been restricted us to like the four wall of the Google Meet box. I thank everyone who has been part of this event and hope to host all of you soon another one this kind of event at the physically at the our campus. So with this language I thank you all of you, and we should be proceeding with the next session. Thank you everyone.
Thank you. Thank you all.
Thank you, sir. I'd now like to welcome Hamza Hamid, sir, qualified lawyer with an advanced LLM from Leiden University in Air and Space Law. Mr. Hamid is currently working as a legal consultant at Unidroit de Rome in Rome, where he primarily works on international secure transactions law. He leads under Unidroit's work on the implementation and advancement of space protocol of the Cape Town Convention. He is also closely involved with the Cape Town Convention academic project and is the manager for fundraising and administration at the Unidroit Foundation. Sir, please.
Thank you very much for that kind introduction. Can you hear me properly?
Yes, sir.
Yes,
I
sir.
just wonder, are we starting now, or are we supposed to have a 15-minute break right now? Because
So
I
we'll
understand.
start right now, sir.
Okay, excellent. That's no problem. Okay, so I'm just going to quickly share my screen. Okay, can someone just confirm that you can see my slides?
No, sir, not as of now.
Not
Yes, sir.
yet?
Now I see.
Now, yes, sir.
Excellent. Well, thank you very much to Professor Bhatt, to Professor Khan, and to Professor Lee for a very insightful first session. And thank you to the Symbiosis Law School in Hyderabad for the kind invitation. As Dr. Kamal mentioned, it would have been an honor to be in Hyderabad right now to deliver this presentation and speak to all of you about some of the new and upcoming activities taking place in the space sector, but I certainly hope to be able to do that sometime in the future. I'm honored to be here, and I'm looking forward to talking to all of you over the next 15 to 20 minutes about the importance of a uniform system of secure transactions law in order to promote asset-based financing in the space sector, and primarily the space protocol of the Cape Town Convention, which is an international treaty designed exactly for these purposes. As was mentioned in the introduction, and as also mentioned by Professor Bhatt in his excellent and extensive introductory session, I work for an international organization called UNIDROIT, and we largely work towards harmonizing and uniforming international commercial law instruments. So I thought I'd start off by sort of laying out the scope of what the private space sector is, and then digging into the importance of a uniform system secure transactions law to the space sector, and then sort of concluding with a few hypothetical examples of cross-border financing of space equipment to see what all of this is that I'm talking about. And this slide here doesn't really need to be stressed that much, keeping in mind that the other presenters have already gone into an introduction. But this is sort of an outlook of the global space economy in 2019, where the entire global space economy was worth over 360 billion. And this is divided into several segments, including ground segments, including space segments. And then on the right, you'll see how this development has grown over time. So as you can see, between 2009 and 2018, there's only 230 satellites that were launched on average, whereas between 2019 to 2028, the number has gone up exponentially. And as some of the previous presenters also mentioned, what we use space for has also started to change, such that while in the past most satellites that were being launched were either telecom satellites or satellites for security services, the prevalence of Earth observation satellites and satellites for the Internet of Things has grown quite a lot. Now, as Dr. Bhatt already mentioned, as the space sector has been growing, the amount of private capital flowing into the space sector is also growing quite fast. These charts on this slide sort of showcase this to a certain extent, where they point out that over the years, the number of private investors in the space sector is growing quite fast, and the numbers which you can see on the right in the millions are also growing quite fast, such that between 2000 and 2006, the total investment was about 1,300 million, whereas between 2000 and 2018, which is a much broader time frame, or if you just look at the third column, 2013 to 2018, it was almost 10 times as much. And all of this private sector investment that's coming through is coming through with various different models, and this includes venture capital, private equity, acquisition financing, seed financing, and all of these are items that are quite important when it comes to the private space sector. Now, when you think of the space sector, many people like to think of the most developed countries in the world, the countries that have large resources, large amounts of budget to spend in these areas. But that's more and more not true anymore, such that if you look at this chart as to where all of these private investments are either coming from or going, you'll see that there's a diverse and large number of countries where private space activities are now taking place. Dr. Bhatt already mentioned some of the activities taking place in India, but broadly across the Asia-Pacific region, including in Southeast Asia, in South Asia, and in Central Asia, there is a lot of space activity taking place, and a lot of the space activity is indeed being financed by the private sector. So when you look at the space sector, and when you historically look at the space sector, you would have always found that actors and companies within the space sector, besides receiving government funding, usually relied upon the financial capacity of their founders. So even now, when you think of some of the big space names that you always see in the news, to SpaceX or Blue Origin, a lot of their financing comes from the pockets of their founders and their owners. Traditionally, private entities have also relied upon mechanisms to attract finance, such as equity financing, mostly through venture capitalists or angel investors, unsecured lending based on the creditworthiness of the entity, or project finance. And then I understand some of the things that I'll be talking about are slightly technical and complicated, so I'll certainly be sticking around for the question and answer sessions. If anyone has any confusions or questions, I'd be very willing to address them. So now, as we looked at, the number of actors being involved in the space sector from different parts of the world is growing quite fast. And then when you look at these three types of financing, private financing, which is equity financing, unsecured lending, and project finance, these are only applicable to a certain type of space company. And these are the very traditional space companies. So traditionally, as most of you probably know, the space industry was comprised of AAA rated companies which have relatively easy access to credit due to their financial stability and creditworthiness. These are companies that rely on obtaining either equity or project finance from lenders at a very acceptable rate, keeping their on-ground balance sheet as collateral. And they've also very heavily often been financed by their own governments that deal with them favorably, considering the importance of the space sector. The space sector is now changing. The space sector is moving more and more towards a new space sector, which is composed more of private entities, smaller entities, and entities looking to profit off of their space activities and have innovative financial models. And this is exactly where the Cape Town Convention comes in. So the Cape Town Convention is an international treaty system which is designed to promote asset-based financing for the leasing and financing of specific types of high-value, mobile, and uniquely identifiable pieces of equipment. The Cape Town Convention... Yeah?
I'm sorry to interrupt, but we are unable to view the slideshow of your PPT.
Okay. Let me try.
You could maybe put it on slideshow mode.
Right, just give me a second.
Apologize for interrupting, sir.
No, I'm glad you did that. Okay. Is that better? Can you see it now?
Yes, sir, we can see it. Could you once try changing the slide?
Did it change?
Yes, yes.
Excellent. So, okay, and please do interrupt me if it stops again. I'm not too sure why I did that. Okay, so I was talking about the Cape Town Convention and its various protocols. So the Cape Town Convention is an international treaty that's designed to promote asset-based financing in various different sectors. It does this by having specific protocols for specific sectors. And up until now, there are 4 protocols to the Cape Town Convention. The first one being for aircraft equipment, the second one being for rail equipment, the third one, which will be the focus of my presentation today, relates to space assets, and then the fourth one being specific to mining, agriculture, and construction equipment. Now, I'll run through some of these slides quickly so that we can talk about the space protocol a little more. The Cape Town Convention in itself has 82 contracting states and has also been approved by the European Union. And the aircraft protocol of the Cape Town Convention has 79 contracting states and is widely regarded as one of the most successful commercial law instruments in the entire world. The main objectives of the Cape Town Convention are 6-fold. Firstly, it facilitates the acquisition and financing of economically important items and mobile equipment by providing for the creation of an international interest which will be recognized in all contracting states. It tries to provide the creditor in any financing transaction with a range of basic default and insolvency-related remedies, and where there is evidence of a default, a means of obtaining speedy relief pending final determination of a claim, to establish an electronic registry for the registration of international interests, which will give notice of their existence to third parties and enable the creditor to preserve its priority against subsequently registered interests and against unregistered interests in the debtor's insolvency, to ensure that through the relevant protocol the particular needs of the industry are met, to grant a contracting state a degree of flexibility in adhering to the international regime by allowing to a well-defined and limited extent policy choices through declarations, and lastly, by these means to give creditors in any transaction greater confidence in their decision to grant credit and enhance the credit receiving receivables and reduce borrowing costs and credit insurance premiums to the advantage of all interested parties. So as the space sector continues to move towards privatization and more private players, the influx of more and more private capital is super important. And this private capital will not flow in until or unless there are financiers, lenders, and banks in the space sector that are willing to lend credit at an acceptable rate. And the Space Protocol tries to bring in all of these key objectives of the Cape Town Convention to the space sector. It tries to enhance legal predictability with regarding the financial viability of space equipment. It allows for the creation of autonomous interests in space equipment, which are internationally enforceable in all states that are parties to the convention and to the Space Protocol. And by creating this international electronic registry, the Space Protocol allows for interests within space assets to be internationally registered, thereby allowing any future investors or creditors in a particular asset to ensure or to just check a registry to ensure whether or not their asset is free of any pre-existing rights or interests. And then perhaps most importantly, what the Space Protocol does is that it provides creditors with a range of basic default and insolvency related remedies, where in the case that a company, and this happens quite often in the private sector, in the case where a space company goes bankrupt, that the financier is able to access those assets and deliver some additional value out of that investment. So what is the Space Protocol and how it works? As many of you being young students perhaps have already thought about setting up your own companies or establishing startups, might recognize that whenever a company or a person goes to the bank or goes to a financier to get access to credit or to get a loan, there are three primary factors that a bank or any financier we will look at. The first one of these factors is the amount of the loan. The second one is the expected value of collateral which can be recovered in the case that you go bankrupt, net any costs of recovery. And then the third one is the degree of certainty over loan payments. And while the Space Protocol has no impact on the amount of the loan or the degree of certainty over loan payments, because both those factors are primarily upon the company itself, it really does impact the expected value of collateral which can be recovered, net any costs of recovery, because what it does is that it provides an international system of insolvency and secure transactions to allow creditors and financiers to recover their assets in the case of an insolvency. The scope of the Space Protocol, and these slides are quite important, so I'll just quickly double check. You can still see them, right? You can still see the slides?
Yes, sir, we can.
Yes.
Excellent. Right, so this is the scope of the Space Protocol, and so the Space Protocol applies to any spacecraft that can be uniquely identified, or any payload that can be uniquely identified. And in fact, it even applies to parts of spacecraft and parts of payloads, as long as they are uniquely identifiable and individually financeable. So if there's a particular space asset that is described or viewed as bankable by itself, such that an investor would want to invest in a particular object and it can be identified, it falls within the scope of the Space Protocol. The Space Protocol allows for the creation of three types of international interests in these types of space assets. These include security agreements, title reservation agreements, and leasing agreements. And then interests of the creditor within these types of assets for these types of interests are protected by registration in the International Registry. Once an interest is registered in the International Registry, it has priority over all subsequent registered interests and unregistered interess. And this is very important because if in the case of an insolvency, the financier then is able to exercise their interest and recover their investment. Now, you must be thinking how that would work in the case of a satellite, because a satellite is in space. So if a company goes bankrupt, how does a financier repossess a space asset, which is not like a car or not like a tractor that the bank can go to the road or the farm and then take their asset back? And the space protocol addresses these issues. So when under the Cape Town Convention, Article 11, there is a default, which is a situation which is either agreed mutually upon by the parties or a standard default where payment is not made to the creditor. The space protocol provides for a system of assignability of debtors' rights and a system of reinforced repossession through transfer of tracking, telemetry, and control within a satellite or a space object. So when a satellite is in space, its most important economic value is the data that it provides or is the information that it sends. And so for a financier to be able to derive value out of an insolvent debtor's space object, the financier has the opportunity through the space protocol to take control of the command codes of the space object and sell them on to another operator. In fact, Article 19 of the space protocol specifically allows for command codes within a space financing transaction to be placed with a neutral third party, so that in the case of a bankruptcy for a space debtor, the command codes or the TT&C documents of the space object automatically transfer to the creditor, which can then sell them forward. Additionally, the space protocol also has lots of other space-specific provisions, which include an exception for public services, so that there's no sudden loss of public services in cases of an insolvency. It includes a clause relating to salvage rights for insurers. It includes provisions for physically linked assets. It includes mechanisms for identification of space assets and many others. And the paper that I plan on submitting alongside this presentation will delve into some of these more specifically. Now, I did put some example transactional structures in this slide, but I do understand that these are very technical and commercial, so I'm not going to go through them in detail. But what I will go through is a hypothetical transaction, which will follow on the next few slides, which will sort of help you understand more clearly what the space protocol is and what the space protocol does. So this is a typical leasing agreement, and this is a typical sale and leaseback agreement, which are both very common when it comes to high value equipment financing and are very commonly used in the aviation sector. And there are two types of agreements that the space protocol can really facilitate in the space sector as well. Now, if you look at this hypothetical, what it lays out is that suppose there is a new space company based in a developing country which is a signatory and has ratified the space protocol. They are manufacturing satellites at the rate of 35 million euros per satellite, and they're looking for funding. And then it points out that there's a bank, XYZ Bank, which is a commercial bank in a highly developed country, which normally only invests in companies with a AAA credit rating. Now, thanks to the certainty provided by the space protocol, XYZ Bank is able to offer a loan to ABC, the space company, which is looking to finance 10 satellites. And so upon accessing this loan, ABC sets up 10 special purpose vehicles, which is and to sort of finance these 10 satellites individually. And the deal is agreed, and XYZ Bank registers the international interest in all of these 10 satellites in the international registry, and then the parties agree that ABC will be in default if it has not paid back its debt for more than 2 months. So once this deal is agreed, once these 10 satellites have been financed, now they're in orbit, ABC launches them and is operating them for 6 months and continues to pay back its loans. But towards the end of its work, ABC now is running low on cash. And even though default hasn't really happened yet, ABC, thanks to the provisions of the space protocol, has the capacity to sell the ownership of these satellites to an anchor client or to a larger to a client that can take on board the obligations that ABC has towards XYZ Bank. So once ABC signs this agreement with this anchor client, what the space protocol allows this company to do is that it allows this company to assign debtors' rights, and namely, which are the rights of payment to XYZ Bank, and thereby allowing for the seamless creation of a structure whereby the loan obligations are taken on directly by this anchor client and allows for the continued functioning of these satellites and allows for XYZ Bank to continue to deliver value from their investment. And now scenario 2, which is sometimes more common, is a scenario where ABC now goes bankrupt and XYZ Bank has to step in. And then thanks to the Cape Town Convention and the Space Protocol, XYZ Bank is easily able to repossess the command codes of these satellites and then sell them on to another operator, all through the international registry, and thereby ensuring that these satellites are still in space, continue to function, and continue to deliver value. So what the Space Protocol does is that it makes investments in space equipment less risky and more feasible for financiers from all parts of the world. These are some of the benefits the aircraft protocol and the MAC protocol of the Cape Town Convention either have already brought or are projected to bring. And the space protocol is also projected to bring similar benefits to the space sector. I understand I'm running a long time, so I will skip through it and come to this, which sort of highlights the startup financing cycle of any company in any sector. And you'll note that as time goes by, risk grows, risk decreases, and different types of financing are available at different stages within the life cycle of a startup. And in interest and treaties such as the Space Protocol of the Cape Town Convention would be applicable where a startup has proven its technology and where a startup has started to go out and seek financing for the launch and development of its fleet or of its satellites. So for the space sector, the Space Protocol would kick in primarily at the early to late stage of investment, which is sometimes where companies find the most amount of difficulty in financing their operations. So in conclusion, with many new space companies being unable to get access to typical forms of financing, especially at later stages, and this is especially even more true now thanks to COVID, which has created a big gap in space financing, the ability to leverage assets in exchange for favorable lending terms may prove to be very important to allow companies within the new space sector to get access to capital. And furthermore, as most startups only have their idea or their assets to leverage and set as collateral, an instrument such as the Space Protocol would allow companies to rely upon their work and their technology to secure financing, as opposed to divesting their stocks or securing loans with very high interest rates. A treaty such as the Space Protocol can be very useful and key for a growing space economy like India, where there's more and more private companies that are entering the space sector and are looking for financing from creditors and financiers based in many different parts of the world. The Space Protocol would allow financiers to lend money with greater confidence and to provide credit at favorable terms. The space sector is projected to be 1.1 trillion or more by 2040, and the ability for players and companies within the space sector to get access to credit based entirely on their work is fundamental. And this is exactly what the Space Protocol promotes, with a goal to create a stable and secure legal environment for transactions in space assets based on a tried and tested mechanism of asset-based financing. I know Professor Bhatt mentioned that the Space Protocol hasn't entered into force yet, but rest assured, UNIDROIT continues to work with international organizations, governments, experts, and others in the space sector, including people in India, to allow governments to get a greater understanding of the Space Protocol and move towards its implementation. And with that, I would welcome any questions or concerns from any of the participants. And I'm available on email if you need any additional information. Thank you.
Thank you, sir. At last, I would like to warmly welcome Attila Sipos, an expert in international aviation law and director of law. He pursued his master's in international air and space law at Leiden University. He served the Hungarian aviation service provider in various positions, including legal director and alliance director. Sir is an honorary professor at the Faculty of Law and Political Sciences at the ELTE University, and as a lecturer teaching regulatory framework of civil and state aviation. Sir is also a member of the International Law Association Space Law Committee. Sir, please.
Oh, yes. Can you see me?
Yes, sir.
I have to switch the light on. Okay. So clear. I am here. Everybody is listening me quite
Yes,
well.
sir. Yes, sir.
All right. Thank you very much. So thank you very much for the invitation. I am very honored. Thank you especially for Professor Sundar P. Bhatt, a good friend of us, and with his leadership, we have a lot of challenge and vision in the Central Europe in terms of space law activity. Thank you for the previous speakers. I enjoyed their presentations and give me a lot of thoughts. I have no PowerPoint presentation, but I promise everything is written in my written text, written paper, and you can read about my thoughts, which I try to summarize via this personal discussion. All right, the topic is, we can divide it two ways. One of the way of the topic is the future of mankind in outer space. Like everything in aviation law and space law, I can look at this way and the other way. I have a contra and pro. I have a good feeling and bad feeling at the same time. And that is the same in the future of mankind in the outer space. One way, of course, it is fantastic. It is not the future, it is the present. We are living in an atomic age. We are living in the space age. We have a lot of benefit and utilization, technological utilization of the space industry. We call this spin-off effects. There are plenty of spin-off effects you can find on the NASA website, for instance, more than 2,000, which is invented and created in the space activity and goes to our everyday life. Look at the firefighting stuff. Look at the sunglasses. In aviation, for instance, the aircraft anti-icing system. A lot of things which belongs to us, and we enjoy the benefit, and we utilize in our every life. And also the GPS system, of course, which is help us every day. Meteorological forecast, the satellite systems, the broadcasting. so the whole day cannot be enough. So one way I am very optimistic and very proud to living in this space age. We opened the door of the outer space in 1957, October 4th, and after we just have an orbit around the Earth in 1961 in April, and also we land on the moon in 1969. Which is a remarkable achievement of mankind and human being. We reached the spiritual approaches, altitudes, and we conquered the outer space, if we want to look at into this prospect. So I'm very proud, very happy. But as I read in the book of Richie Lee, Professor Richie Lee, he wrote about the Stone Age, the Bronze Age, the Iron Age, and yes, we are in the atomic age as well. And because of Monsieur Hamza is from Italy, yes, we have started the atomic age in 1942, December 6th, when the Italian physicist Enrico Fermi and the Hungarian physicist Leo Szilard just directed the first controlled chain reaction which involving a nuclear fusion, and that was the starting atomic age. So the other way, I am a little bit sad and pessimistic, because if you look at the history after the Second World War, we face immediately with the Cold War. This is from 1947 till 1991. If you look at the latest report of the World Nuclear Weapon Stockpile report, we can see there are more than 13,355 nuclear weapons registered, which is not bad compared with the previous decades. So it's less and less every year, but still plenty of nuclear weapons are registered and made it by the atomic powers. But if you look at the doomsday clock, which is not only just a comics from the Watchmen, this is the reality. We can see this reality if you go to the website of the doomsday clock. And if you look at the last year report, closer than ever, it is 100 seconds to midnight. You know, the doomsday clock shows the end, that day when the mankind destroy themselves. And this 100 seconds, which was in 2020. Now in 2021, because the new report just came out last week, it shows we are in the same position. So nothing happened. We are the closest than ever to the judgment day or the doomsday, because of the climate change, because of the asteroid strikes maybe happen, the epidemics we are facing with the COVID-19, as everybody knows, and the overpopulation. So there are plenty of things. And if you look at the Stephen Hawking report or book, it also says in his book, what is the title of his book? Yes, humanity only has 100 years left on Earth before doomsday. So one way I said it, I'm very proud, I'm very happy, and enjoy the benefits till today, and in the future with the mining and the other activities, of course. But the other way, I'm very pessimistic, because what is the guarantee? That kind of things that we have done here on the planet Earth, we are not going to continue in outer space, because the guarantee cannot be only few states are capable to mine, capable to active on outer space or the other celestial bodies, because the Cold War was also based on two major states, and that competition and fight, if I can say. So that is that kind of ambivalent feeling will determine my speech. So I think I can close this the first part of this presentation, the future of mankind. It is I am skeptical about the future of mankind in outer space, but there is no way. We have to go. We have to explore and exploit at the end of the day, because that is our nature as well. All right, and don't never forget, if we are talking about mining, and that will be the topic of my next stage of the ownership, focusing for the ownership, the most valuable resource is not the platinum or iron or titanium and the other raw materials. The most valuable resource still in outer space is the water. Water is crucially important as far as you know, and water is still very important on the planet Earth for our everyday life as well. All right, ownership. That is the second part of my presentation, which is a very complex issue. I wanted to define what is ownership. What is ownership? There are plenty of different definitions. Of course, the Roman law, it was very simple. The Roman law divided for dominium and possessio. You know, the dominium was the absolute right, and the possession was how to physically control that item. It was in Roman law. It was very clear. It was absolute, and it was protected by law quite well. Nowadays, in the modern law, modern societies, the ownership doesn't imply or indicate absolute or unlimited rights, either use, disposal, or duration. So when I try to figure out what is the definition of ownership, also we know very well as a legal person, of course, we have a right to possess, we have a right to destroy, we have a right to use, control, right to exclusion, and also the right to incomes. Yes, we have a plenty of rights, but if you look at the different legal systems, the definition of and the meaning of the legal meaning of the ownership is different. It differs from every culture, and of course it differs vary according to the national laws. So that is very strange. I would like to speak about ownership, but I don't have a proper definition. But doesn't matter, because I can find a proper definition in regards of the legal status and ownership status, or ownership and control status of outer space. Yes, the outer space is very clear. Look at the Outer Space Treaty, Article 2. Look at the first resolution, UN resolution, UN Copulos resolution. It's also dealing with the ownership things. It is the resolution 1721, the international cooperation in the peaceful uses of outer space. So these resolutions, also the Outer Space Treaty, is a basic principle and shows very clearly the outer space belongs to all of us. It is res communis omnium usus. Everybody can use freely. No one can monopolize in any way. Cannot be controlled, etc., etc. So for me, it's very simple. But I have found a different views. I have found a different prospect, different approaches, which makes me a little bit confused. What kind of things that I am going to face, or you can face as well. First of all, just look at the media, and you can see there are business people just selling land on the moon or Mars or any other celestial bodies, and they make a huge amount of profit, and they become very rich. And although they are very proud, some of the United States presidents also bought that kind of land, and as it's a kind of advertisement, the others is following, and there are 6 million, for instance, clients, one of the major businessmen in their stock. So, of course, if you look at carefully, the situation is, as a lawyer, you know very well the answer. That is nonsense, that is fraud, that is the Schwindler category, of course, because we know very well the Roman principle, nemo plus juris transfer potest quam ipse habet. It means nobody can transfer more rights than his own. So the owner can transfer their property to the others, and that if he's not legally protected, the rights is not legally protected, he cannot transfer those things that not belongs to him, and that is the first things which is create a little confusion. But it's very clear that it's impossible to sell those kind of things, not because of the Outer Space Treaty itself and the resolution, because of the Roman law and Roman system. This is principle, and this is living in the civil law system everywhere. And secondly, also which is very interesting, the privatorium convertio iuri publicum non derogata, which means also the private person cannot derogate from public law. So the private person has no more rights than the public. The individual cannot be above to the community and to the nation. So that kind of things also that allow to transfer this kind of land or territory. And also, if you look at the target of the sales, it is targeted the impossible object. It is impossible object. We cannot possess that. We cannot go to the moon and to show my friend, this is my land. Look at I can use it. I can derive the incomes, and I can do something else. So that is totally impossible, which means the legal consequences of this, the nullity of the contract. First of all. Secondly, when we open the media, what we can see? We can see just 3 days ago, the Sotheby auction house sold few samples from the moon, officially sold. The unnamed buyers paid a lot of money for the 0.2 grams 3 pieces moon sample, which was came down to the Earth by the Luna 16 mission, the Soviet mission at that time, and the Soviets decided to sell those 3 samples by Sotheby in 1993, and this for a huge amount of money. And if you look at the media, you can read the article which says Soviet lunar samples sell for $855,000. I said it's 2 milligram only altogether, these 3 pieces, but more maybe on the illicit market. They are selling. It's a commercial business. We can sell by Sotheby on the market or in the black market as well. Also, if you look at carefully the news, you know very well the United States, Japan, the European Union and China were able to bring down samples from the moon and other celestial bodies in the history. And if you look at the US and Japan, was very generous and share these kind of moon samples, which was from the Apollo mission is 382 kilograms, so it's quite a huge amount. They shared with the public, with the others for educational purposes, shared to send to the museums or scientific explanation or whatever reasons. But if you read carefully, there are few of them are missing. So they haven't found just as I heard in Romania, for instance, the president at that time, the Romanian president sold those moon samples and they make a huge profit on it. And now the NASA tried to collect back those samples which are disappeared or missing or stolen somehow. That is also interesting. And also that is very interesting when we are just finding a meteorite on planet Earth. There are 2 ways we can find, of course. One way, we are just walking on the land and we found something, and the other way, the human or mankind or the astronaut will bring down from the celestial bodies to planet Earth. So the 2 ways. One way is when you found on the land. It's very simple. It's a res nullius. According to the Roman law, the res nullius credit primo occupanti. It means you can occupy that, you can have an ownership, but not in everywhere. As I said, I told you in the beginning, I'm always a little bit confused. One way, it's very simple. Yes, you found something, it's not belongs to anybody, you can occupy, but not in every jurisdiction. If you look at the national law systems in the United States or France, yes, you can. It is yours if you find it. Of course, not is of course not if is it deep down in the earth and you dig it and find it, because it still belongs to the state. But if you find on the surface of the planet Earth, it belongs to you. But there are the other countries which says no, it is automatically goes to the property ownership of the state. For instance, United Arab Emirates or Australia, and also India. For instance, India, because this our industry is aviation industry and aerospace, and space industry is a conservative discipline, a conservative business. Really, it's very fantastic. The India legislator dealt with this issue in more than 135 years ago. They said it's India resolution, government resolution says all falls of aerolites has to be forwarded to the government geological museum, Calcutta. So it is, of course, the compensation is not paid for the finders. It's not, of course, because in many civil law system, of course, they are compensated, but there was no compensation at that time. I don't know how changed this regulation the last 135 years, but they dealt with us. You have to present to the local police or the geological museum in Calcutta. So that is also some divided. But the other way, when the mankind or the human being brings down to the earth from the moon or the other celestial bodies from those kind of mineral, that kind of samples, or any kind of cosmical stuff, that is very interesting, because when we are talking about space mining, it is not the case nowadays. Of course, that is the future. So, or I can say another word, it is a long-term vision, because if you look at the nowadays the system, the NASA, for instance, the NASA in the Stardust mission, the Stardust aircraft just collected 1 milligram dust from the Val-2 comet and brings down to the Earth. This mission was cost more than $200 million, and only a very small amount of which is historically unique, because they can touch, they can close to the comet, which is very, very unique in the history. But if you look at the Japanese Aerospace Exploration Agency, the JAXA mission, the Peregrine Falcon aircraft is also brings down in 2010, sorry for that, 2010 from the asteroid 1 milligram samples. So 1 milligram, of course, 382 kilograms in Apollo mission, which was in 6 times, of course, touched the moon, and the astronauts spending 12 days on the moon. But if you look at the reality, for instance, the Osiris-Rex aircraft, which was launched by NASA in 2016, which will come back soon in 2023. They are on the mission back from the Bennu asteroid. They just collected 60 grams samples, which is also a huge amount. But this mission costs hundreds and hundreds of $millions, so it is very cost effective and very cost demanding and very risky operation, if I can say. So not an easy. So I think the mining and the utilization, those kind of mineral resources, mainly is happening on the surface of the moon, of the Mars, and other celestial body. That is economically right, and also support the mission and the other future missions as well. Okay. So hold on, as Professor Bhatt said, Sandapi Bhatt said, hold on, where is the law? There is the law. There is the law. Outer Space Treaty and the resolutions, not even one resolution. There are 5 resolutions, and 2 is dealing with this issue. And also we have, of course, the Moon Agreement, which is under-ratified, we know very well. But what is the solution? Do we need more law, new law, or modify the law, as Ricky Lee suggested to the Indian colleagues, for instance, ratify the Moon Agreement and review and hold the review of the conference to negotiate, or just to find another solution. So there is one way, we ratify something which exists, we modify, we create a new one, or there is other way. Yes, there are other ways. We call this unilateral actions. What does it mean? If you look at the situation right now, President Trump, the former president of the United States, in 2020, the 16th of April, so 6th of April says, just look at the article. Introduce the executive order. Executive order is encouraging international support for the recovery and use of space resources. And this executive order says in 2020, in April last year, the Americans should have the right to engage in commercial exploration, recovery, and use of resources in outer space. Of course, consistent with the applicable law. And outer space is legally and physically unique domain of human activity, and the United States does not view as it a global commons. It is not as a global commons. So you can have ownership on it. You can utilize, yes, not in territorial jurisdiction, not in a way of territory, but those things which you exploit, which you mine, it will be yours. What does it mean it will be yours? It means you can carry on, you can transport, you can possess, and at the end of the day, you can sell it because it will be yours of the benefit of the raw materials of the items or goods on the surface of the moon or other celestial bodies. So the unilateral way is one very popular way nowadays. If you look at the US law in 2015, that is the Commercial Space Launch Competitiveness Act, which also dealing with this issue. They said it is possible to exploit, and you can possess and you can sell it, as I mentioned previously. There are law in Luxembourg as well. Luxembourg is a very small country, you know very well. They don't have nothing special, but they are one of the richest countries in the world, and the business center, one of the biggest business centers of the world. Very small country, small population, nothing they don't have, but they have vision. They are unilaterally introduced their own Space Act, which is only 18 articles, and open the door to the others. It is a door because Luxembourg is member of the European Union. It means if you deal with Luxembourg, it is also, you have a connection to Germany, France, and the other countries who are also playing an important role in outer space industry and also civil aviation as well. United Arab Emirates was mentioned as well. Yes, they have also introduced in 2019, December, came into effect their law, the legal, which is dealing with outer space. Of course, they give the example of the high sea. If you go, why do you go to the high sea? You go because of fishing. And what do you do with the fish? Of course, you are going to eat and sell it. And the outer, we know very well the high seas, and above the high seas, the international airspace and the outer space, they have the same legal status. They are the res communis omnium usus as well. So the unilateral way is very interesting. There are now few countries, they have their own legislation and dealing and focusing for the ownership rights and control, of course, which is two things coming into my mind. First of all, if every, of course, it's utopia, so this is just a vision. If every state at the end of the day will have their own national legislation, which is the case now, there are 35 states in the world has got, according to my survey, they has got a national Space Act or legislation. For instance, the European Union, we have 27, we have 22 member states has their own special acts or legislation which dealing with outer space. So if every state has dealing in the same way, yes, territorial way, no, it's not occupied, it's not possible, of course, and of course in the light and the in the light of the international law, of course, and outer space, or but the other or inconsistent. But the other way, if they say yes, exploitation. Those materials belongs to you and you can possess it. It means finally, at the end of the day, if every state has got the same way of thinking, finally it is solved the issue, which will be not the case, of course, because it is unilateral level, nobody and not everybody is keen on and everybody is satisfied with this unilateral way. But the other things in the unilateral way is very, I think, is very important. If, for instance, the other country like China or India will start mining on the moon or other celestial, mining means it's a wider prospect. So start commercial activity. The United States, the United Emirates or Luxembourg, they cannot complain because you are met with, they cannot complain. They cannot say, hey, this is against the Outer Space Treaty or this is against the principles which I mentioned in the beginning. No, so that is also opening the way and it's built a kind of coalition. So unilateral way try to rebuild the system which exists because lack of time, because the technological impact is faster than the legal background or regulations. Yes, they try to rebuild the system and build a coalition or build their own way. It is very common in civil aviation, for instance. In civil aviation, for instance, we have also ownership, substantial ownership and effective control clause. If Air India wants to fly to China or wants to fly to Australia or any other country in the world, the Air India has to be owned minimum 51% by Indian government or Indian citizen, and also as a national, as a not a national airline, I don't call because the European Union we don't use national airlines anymore. We use community carrier, but as a designated airline, they have to fulfill this clause, the ownership and the control. It has to be controlled by Indian people as well in the board of directors and also in the CEO and the others. So that is also exist, and this is a hindrance, this ownership control for civil aviation. That's why few states rebuilt this kind of system by unilateral level, which a little bit more multilateral, but finally in the beginning they started a unilateral way. They open, for instance, like mentioned by Professor Ricky Lee, the Artemis Accord. The Artemis Accord is also one way is unilateral, but slowly getting bigger and bigger and can be multilateral. But it was not mentioned that is not an international law because it's just an accord, which means it cannot be implemented into the UN COPUS system. It cannot be enforceable because that is not a legally enforceable, or this is not a law. It is just it is not an international contract at all. It is just a principle, a vision of 10 principles which dealing with a very important issue, and two of them are very, very important in regards of the ownership, because one of them says that if I'm run out of time, please tell me in time, because I can tell you a lot, and I am writing a lot to you. I promised, as I promised in the beginning. Please, can you listen?
Yes, sir, we can.
Yes, sir.
Okay, all right. Okay, thank you. Good. So the Artemis Accord, for instance, Artemis is a twin of Apollo. Apollo mission. Now we have Artemis mission, and Artemis mission. Of course, goal is the NASA will send, of course, 2 astronauts to the moon pretty soon. They built their own facilities, and also they want to have cooperation, wider cooperation on international level. And that is a good attempt, also a good attempt, not only just unilateral, but we opening on a multilateral. It's open, everybody can join, of course, but 2 things I have to mention, just to avoid conflicts, the section 10 says, the space resources says, yes, you can exploit, you can utilize, you can extract those things, but in compliance with the Outer Space Treaty, Article 1. And also it is, which is very interesting in the section 11, it says you can build a safety zone, which is not in territorial. It's very interesting. I have a safety zone. I start the mining this part of the moon or the other celestial bodies, I make this safety zone, and which arising a lot of questions. This is in maritime law. It's happening in the artificial island. You can have a 500 meters safety zone around them, but there are a lot of obligations and rights which you have to follow with this, so you cannot jeopardize the free transportation to the others, etc., etc. But the safety zone can be wider and wider. It depends on the activity. So it arising a lot of questions. But Australia is a sign. Is joining to this accord, which is very interesting because they are ratified party of the Moon Agreement, and according to the Australian government, of course, it is they can consist. So there is a lot of thoughts which can be handled together with the Moon Agreement and also with this Artemis Accord. So there are plenty of issues, and as I said, the unilateral way is works in the aviation industry. If we look at the overflights if you look at the ADIS, the air defense identity zone, which is also unilateral level design, and India and plenty of states now has got ADIS zone and protect their territory, and this 12 nautical miles. Which is quite not enough. Strong, faster aircraft, and they have to secure and protect their nation, which is very understandable. So the other way, what is multilateral approach? Okay, not everybody is satisfied. Russians, for instance, they refuse that kind of way, as US and the United Arab Emirates and the others are behaving. Brazil are not satisfied this kind of actions. They want to have multilateral level. They want to find a level. How can we find a level? Yes, outer space treaty we modified somehow. It is very complex issue. Or if you look at the UN COPUS system, it's a consensual system. So they have 95 members right now. So it's nearly impossible to find 95 votes. Those kind of activity. If you look at the outer space treaty as an international law, an international contract, it is also very risky to modify. If you look at the Chicago Conventions, for instance, the Chicago Convention was modified a few times in the history, and the modification arises ununification as well. What does it mean? If, for instance, the Chicago Convention has 193 member states, but those modifications modified by different numbers of the states. Some of them modified only for instance, 3 bits only 170 states. The 83 bits maybe 120 states. So when you read the convention, you have to be aware. Not every sentence is ratified by each state. So it is against the unification, and the international law major goal is the peace, and the second major goal is the unification, unify the legal system in the world. So that is also not the case, and so we have, and also it takes a lot of time. So if we modify a few articles, maybe it comes into force maybe 10 or 14 or 15 years. In the Chicago Convention, that is the case. Minimum average is 10 years when they came into force. Although everybody's agreed, everybody was satisfied with the result on the assembly, and everybody wants to ratify, but it takes a lot of time because of political and the other circumstances. Just finalize my speech because I think I am close to the end. So what is my message? My message is very simple. What I believe right now, what I am very proud of, we are, according to Carl Sagan, which you know very well, all of you. Carl Sagan said we are representing 14,000 generation on planet Earth. So we don't have to invent the wheels. We don't have to invent the jet engine anymore. They have invented. We have to invent another things. We have to be aerospace lawyer, as Ricky Lee told you have to follow the space opportunities, but I say the aviation opportunities as well. So aerospace opportunities, I think, is better words in this regard. So my message is we representing 40,000 generation, and the doomsday clock shows us 100 seconds only. So we don't have much time, but we have to follow Brahe words. He was an astrological person from Czech Republic. He said, "Let us not seem to have lived in vain." So that is what I try to send you a message. We have to work very hard. We have to build ourselves. We have to build the country. And at the end of the day, our life will not seem we lived in vain. Thank you very much.
Thank you so much, sir. Let's now move forward with the presentations. The first presentation will be done by Ms. Upasana Dasgupta on regulatory regime and space sector in India and state responsibility. Ms. Upasana, if you could please give a brief introduction about yourself and then continue with the presentation.
Thank you. So firstly, I would like to thank the organizers for organizing this great conference on the very topical theme. So I am a doctoral student at McGill University, Institute of Air and Space Law. And my supervisor is Professor Ram Jaku, and I work on space debris, space environment. Basically, my thesis topic is preventing collisions in outer space and towards better state responsibility implementation. So that's briefly my introduction. And so I have been interested in space law for since my college days in RMNLU, and since around 2009. And so it has been a great experience, and I would like to speak about something that is very close to my heart, which is the state responsibility and the regulatory regime sector in India. To give a brief introduction, Article 6 of the Outer Space Treaty provides that the private parties are responsible for, the state is responsible for any act of the private parties, which is basically what we have been talking about today morning, is that what the state's right, the private parties' rights cannot be more than what the state's rights are in general. And this is even more important in space law, because in space law, Article 6 of the Outer Space Treaty specifically says that a state assumes direct responsibility for any act that is done by its private party. And it basically means if I, as an Indian citizen, do something which is violative of international law, India would be directly responsible for that. So it is as clear as that, and that is different from that is a little different from what it is there in general international law, where if you do not take action against a person or a entity, or a natural person or an artificial person, then you are responsible as a state. But here, as a state, you are directly responsible. So the question is, what does that mean, the direct responsibility? Does it mean that a state has to have laws? So the interpretation that Article 6, which I believe is the interpretation that is correct, is that there is no obligation on the states to have to enact laws, because that is an internal matter of the state. And a lot of the states now are right now are dualist. So you cannot say that it is that the state has to enact laws. That is basically getting into the internal matter of the state. But what international law can say that you are supposed to supervise the actions of private parties, which is what Article 6 of the Outer Space Treaty says. Now the question is that the reason? So what is the reason we should have laws? So it's very simple. Article 6 does not mandate it. There's no other space law that mandates it. So why is it important? Firstly, because supervision is much more easier if there is a law. That is the first important thing. And secondly, and most important thing, is that law brings certain certainty. And when things are properly defined, sometimes it really helps the regulations are clear. It really helps the system. So the whole idea is to have a certainty. And in fact, that is a reason that US came up with the 2015 law on space mining, and Luxembourg tried to have a law on the similar subject. And the reason they wanted to have a law is national law, is because they believe that national law would bring certainty for the private parties within their state. So without going into the whether these laws violate or not violate in national space law, I just wanted to make a point that these laws were enacted so as to bring certainty, which is the most important thing for private parties. So I just want to show something about the recent Spacecom policy. Is it possible? Can I share my screen?
Yes, ma'am. You may share your screen.
Okay. So can you see this? Can you see a like a page with comments?
Yes, ma'am.
Okay, so this is the draft Spacecom policy which India came up with in 2020, and if you look at the definition section, it was pretty clear. But I just wanted to show that there are certain things which were missing. Like for example, they use the term authorizing authority, and then they use the term UN treaties or on outer space, but those were not defined. So it's very important to define things and make sure that these are in consonance with the international obligations. Because what happens if I would like to show something else. So for example, it does not mention ITU documents also. That is another thing. It doesn't mention the details about ITU documents and what is the which precedes which one. And it's important to write these in the national laws or policies, because this help in because the private players, they are not looking into the international law. Like that is not their obligation, especially in a dualist country like India, where private players are not bound by international law per se. Of course, there's something in our fundamental duties which says that, and a fundamental and I think in the directive principles also, that we should respect the international law generally. But then, as a dualist country, unless the state comes and transforms international law into a national law, I think it becomes difficult for a private party to enforce, to know what to do, basically. So I just wanted to show certain things, some more things here. So this is, for example, it doesn't mention the Spacecom policy. It doesn't mention, it says things like member of the UN bodies. So there are certain places where it doesn't mention what are the UN bodies. So basically what I'm saying is clarity is very important, and that is the important thing for generally for a private party. So that is my limited point, that there should be clarity for private parties to start to start their policy, to start their own policies, because their policies, their internal policies, their actions would be dependent on what the government is taking. And this is even more important in national space law, where I mean, I will not say that the Outer Space Treaty or the laws are or the Outer Space Treaty is not clear, but what I can say is that because it's not because there are various interpretations which can be taken, so it's really good for a country, for a private player to know what stance their national government is taking. So that is the most important thing, and that is very important for private players. So my limited point here is that there is no international obligation per se which says that a state should supervise should have national space laws. There's nothing that mandates internationally for India to have national space laws. But if we have national space laws, it will help the private sector. And the question is, should it be whether it should be too restrictive or not is of course a very valid point, which is why when we had the draft space the Space Act basically in 2017, so around December. So I think that is why the private players came up and commented. So it is important to have a law that helps the private sector, but it's also important that that national law is in consonance with international obligations. Otherwise, the country has to pay compensation of huge amount, which would involve the taxpayers' money. I think my time is up, and that is briefly my presentation. If you have any questions, comments, please let me know, and I can be reached at my email ID. This is my email ID at any time you would like to. Thank you.
Thank you, ma'am. The next presentation would be by Akanksha Marwa on common heritage of mankind and conundrum of outer space privatization through the lens of outer space commercialization. Ms. Akanksha, if you could please give a brief introduction about yourself and then continue with the presentation.
Sure. Thank you so much for giving me the opportunity. I am Akanksha Marwa. I am the assistant professor in the Delhi Metropolitan Education, Noida. This college is affiliated to GGS IPU New Delhi. And I've also taken a few guest lectures in the Diploma of Air and Space Law in the Jamia Millia Islamia. The same university I did my LLM from in the criminal laws. So can I start sharing my presentation now?
Yes, ma'am, you may.
Okay, thank you. Okay, so while my screen is getting shared, I would start from the limited point that I will be talking about the one principle, basically focusing upon the one principle of space law, which is the most contentious one, as already pointed out by Dr. Ricky Lee. Is my presentation visible?
Yes, ma'am, it is.
Okay.
Yes, ma'am.
So in my
Could you once
title, I
try
have.
changing the slides before you proceed?
Is it changing?
Yeah, yes, ma'am.
Okay. So in the title, I have mentioned common heritage of humankind. So first of all, the terminology which is used in all of the outer space treaties and conventions, the word uses mankind, but I preferred using humankind since it gives a more gender neutral approach. And why I want to focus on this principle, as I've already mentioned, is the most contentious concern that we have today. And before moving on to my objectives, I want to start from the ground that privatization and commercialization of the outer space, is the future. We have seen the increased requirement of the space-based activities in the last few decades, I would say. And because of this, there is a new generation of new space coming up. The new space refers to the term where we say that the activities in the outer space, which were earlier taken up by the governmental agencies or the government, have now been taken up by the private entities. And because of which, there is an escalation of commercial space activities, wherein the private actors, they are investing money, they are putting in their resources for providing goods and services to the consumers. And that may be for various purposes, whether it is for telecommunication, whether it is for navigation, or even space tourism. Now, because of all these increased space-based activities, it is believed that if certain functions are transferred to the private companies, the space agencies, they would have more resources, more time, and they can dedicate their efforts to limited areas, which are the research and development for the exploration of the outer space. And this would consequently lead to the effective utilization of the limited resources and the cost effectiveness. And one thing which has already been discussed till now in various presentations, that non-governmental activities, agencies indulging into space activities, was also anticipated in the treaties. Like in Outer Space Treaty, there is Article 6. In Moon Agreement, there is Article 14, which says that every nation would have an international responsibilities for the activities which would be taken up by the non-governmental entities or non-governmental agencies. And in Liability Convention also, if the expanded interpretation is used, the launching state would include the state from whose territory any activity was undertaken. And also, I have a few examples here which depict how the commercialization and privatization has been happening around the world in the outer space operations, whether it is US for enacting an act, Space Act in 2015 for promoting the engagement of private actors, or it is India where a lot of activities have been transferred to the private actors, and there are space startups like ARDL and Agnikul Cosmos, Astrom, and others who are indulging in the outer space operations. Now, coming in terms with the fact that privatization is happening around the world, including India, my objectives are very focused to the points that is this privatization and commercialization which is happening today in tandem with the principles of outer space. Whether when we are indulging in privatizations, we are giving that respect, we are obliging ourselves to follow those principles. In the space exploration, we have come to the terms that outer space has the common interest of all the nations. And because of this common interest, this outer space can only be used for peaceful purposes. Every state would have an equal access to it. There cannot be any sovereignty claimed by any nation in the outer space, and that can be used only for the benefit of entire humankind. Now, in the Outer Space Treaty, which is the first treaty, and obviously followed by many of the nations, the outer space has been called the province of humankind. But this situation changed a little bit in the Moon Agreement in 1979, when the exploration and the resources of outer space, Moon and other celestial bodies, was called a common heritage of humankind. And because of this terminology, which is a very stricter thing to say that entire resources in the outer space are the common heritage, there are certain restrictions which are placed on the activities of the nations. Now, the province of mankind, humankind principle says that, which is in Article 1 of the OST and in the Article 4 of the Moon Agreement, the outer space belongs to the entire humankind. And no nation can claim sovereignty. The area can be used for peaceful purposes only, and the expeditions and the explorations made shall be only for the benefit of all the nations, irrespective of the scientific and economic development. On the other hand, the common heritage of humankind principle based upon the 5 elements which were given by Albert Pardo, who was the ambassador from Malta. He said that first of all, there cannot be any appropriation, and secondly, which is most contentious concern, is that there would be sharing of benefits. Despite the level of participation of the nations, irrespective of their scientific and economic development, the benefits which are derived from the exploration, they shall be shared amongst the nation. And because of this, there are certain issues which come up in the privatization. So we can come in the terms with the fact that the principle of common heritage of mankind, it gives us various benefits. That first of all, it makes the entire world community as one single entity, wherein the activities would be conducted in the outer space and the benefits would be shared by all. And therefore, it acts to deliver social justice and economic justice to the countries which are not able to conduct any space activities because of low level of research and development or lesser economic resources available with them. So the issues that come up are, first of all, that Moon Agreement, as already pointed out in the earlier presentations, has only been ratified by the less number of countries, and even India has only signed it and not ratified it. So the developed countries, which are more technologically advanced and the economically greater well-off, they are not interested in sharing the benefits with the countries who have not contributed in any way to the development, to the explorations, to the activities that they have conducted. So when they are not interested, they often call it the Moon Treaty, which actually has this principle of common heritage of humankind, a dead one. Or even they go to the extent of calling it a myth. So first of all, it is not clear as to whether the common heritage of humankind should be followed or not, but because of the benefits that it gives, it is highly recommended by various lawyers and other experts that it should be adopted in the exploration of the outer space. The issue that arises because of this principle to the privatization is that there are 3 expectations of the private sector whenever they start their operations in the outer space. They expect certain securities, they expect certain benefits, they expect return on the research and development they have been conducting in their, they have been doing in their outer space operations, and obviously they expect a stable legal environment, which means that there should be some national laws regulating the launches, regulating the permits, permissions, liabilities, the financing, and all other things, which would give them a stable legal environment, security, so that they can have certain benefits from their operations. But here then comes the conundrum, the question as to whether private actors would be interested in entering into a scenario where the benefits have to be shared. Because when private actors are going into outer space, they would expect, they would demand the first in time, first in right approach. They would expect the intellectual property rights benefit. They would expect the property rights from the activities that they are conducting. So these are the certain challenges that would be present if privatization is there and the legal scenario is not free from ambiguities, keeping in mind the different interpretations of the terms which are used in the treaties and conventions or in the national laws. Then there are also other questions related to the expeditions that might be coming up in future, like space tourism. If there, how the infrastructure would be created, what would be the rights of those who are going into the ventures of space tourism, and then, as already pointed out by speakers earlier, what would be the status of the tourists who are going into the outer space? The rescue agreement only talks about the rescue of the astronauts, who are the envoys of humankind, who are the envoys of the humans in the outer space, because they have been given that stature to represent the humanity in the outer space. But the tourists, they are only going there as a vocationalist. So that is going to be one of the other problem if we do not solve the questions of ambiguities in the international treaties and conventions. And yes, of course, finally, the environmental protection and the debris mitigation, which is increasingly getting attention in the outer space because of the increasing environmental pollution in the outer space. So I would only restrict my presentation to these issues. And I would only suggest that, first of all, the outer space should not become any Cold War area for the spacefaring nations who are developing their technologies. And secondly, the countries who do not have the technology right now, their rights should also be secured so that they can also enjoy the benefits of the exploration from the outer space, because they are also the stakeholders. The entire outer space, even if you call it a province of humankind, the benefits are to be received by everybody irrespective of their development. So this would require, as Upasna Das Gupta ma'am already mentioned, that national laws are preferable because they give a kind of certainty. So every country should have a national law which should be in consonance with the international obligations of the countries. Then upgradation and review and upgradation of the international instruments, which were although they cover all the points, but yes, they do need an upgradation, keeping in mind the current technologies, current developments, and the legal challenges that have been arising. And we can also think of establishing an international regulated authority like we have ITU, so that the questions can be taken up specifically to that authority for any solutions. Thank you for giving me the opportunity to share my views. If there are any questions, I would drop my email ID in the chat box.
Thank you, ma'am. The next presentation will be by Dr. Bishwanath Gupta on law and security issues in commercial outer space activities, a case of India. Sir, if you could please introduce yourself and then continue with the presentation.
Yeah, good morning, everyone. I hope I am audible. Am I audible clearly?
Yes, sir, you are.
Yes, sir, you are.
Sorry. Okay. So I'm Dr. Vishwanath Gupta. I'm presently working in OP Jindal Global University. I'm assistant professor of law there. My area, I basically teach public international law, but my research interest is in international space law. So the paper that today I'll be presenting, it is law and security issues in commercial space activities, a case study of India. I already mailed these slides. I'll request the organizer to kindly display the slides if possible. So if you read the title that I have set up, that is law and security issues in commercial outer space activities. So the word security, you have seen, it got a lot of emphasis in United Nations Charter. Article 2 of UN Charter says that one of the objective of international law is the maintenance of international peace and security. So in that context, once you are entering into the private activities in India, we have to ensure the internal security of India. Now, very recently, we know that government of India has taken initiative to pass the national space legislation. And there are two important organizations that government of India has actually decided. One is the InSpace, and second one is NSIL, National Space Insurance Limited. So these two institutions will actually govern the entire private space activities in India. Though government has talked about these two institutes or two organizations which will primarily govern the private space activities in India, but still it has not come out with any structure or kind of mechanism how these two institutions will actually operate in India. Now, the security issues that are primarily involved. Security issues has two aspects. Thank you. Yeah. Okay. Can you please just move on to the third slide? Yeah. So the security issues that are basically involved in space activities, there are upstream and low. We all know there are upstream and lower stream activities in space. So in upstream activities, we have telecommunication, broadcasting, GPS operation, or the satellite or remote sensing. The upstream, these are mainly satellite remote sensing, these activities. And the lower stream applications are basically the telecommunication, broadcasting, and GPS. So this kind of activities actually creates a new amount of security concerns to a state. Those countries who already adopted national space legislation, such as US, France, UK, and who are actually heavily investing in privatization of outer space activities, they have developed a mechanism how they can handle the security issues while handling the private outer space activities. But in case of India, what we have seen, uh, we do not have any specific legislation at place. At the same time, the policies that we are having are not well equipped to address the issue of security that we'll face once we largely allow the private parties to enter into Indian space activities. So the first thing that I'll request to go to the next slide. So how we can make a good approach, a balancing approach, so that in one hand we can address the issues of industry. On the second hand, we can also address the issue of governmental concerns. So the legislation somehow has to play a balancing approach. We cannot make a law. Uh, why I am saying, because we are actually at the stage when we are actually planning to draft a legislation for governing space activities as well as private space activities in India. So the legislation has to address both these issues. If the legislation passes or enacts law which will only protect the interest of the government without addressing the industrial concerns, the private space activities movement that government of India started, will soon see failure. On the other hand, if you only see industrial interest without taking proper care and caution for the security aspect of that, that will be also a disastrous. So that's why legislation has to take this balancing approach. Now, the two institutions that I was talking about, the InSpace as well as the NSIL, these are the two institute has to come up with some regulatory framework so that how they can balance the industry interest as well as the governmental interest. So unless like in very recently we have seen government under the Atmanirbhar plan or self-reliant India plan, government has opened the FDI in the space industry up to 100%. And very recently we have seen some of the private companies are also involved in the Indian space activities. PSLVs are proposed to manufacture for the manufacturing of the PSLV are also proposed privately. So these are the things that are coming up in India. But unless we made a very specific suggestions how will make this balancing approach. I think this private industry promotion of space industry in India will not be a successful venture. So with this, I end here. I'm thankful to the organizing committee, especially Dr. Shailendra Kumar, for giving me this opportunity to speak before this august audience. Thank you. Over to you.
Thank you, sir. We'll now move on with the question and answer session. Sorry, there has been a change. The next presentation will be by Dr. Devaprasad M. on the new space and emerging challenges for the international space law framework. Sir, if you could please give a brief introduction about yourself and then continue with the presentation.
A very good afternoon to all of you. Yeah, so I'll just share the presentation, then start. Just one second. I hope it's visible.
No, sir.
Sorry, it.
You'll have to share the PPT. Yes, sir. Now, yes. Could you once try changing the slide?
I'll just try that. I hope it's visible.
Yes, sir.
Yeah. Fine. Thank you, everyone. Yeah. So, good afternoon to everyone. A big thanks to Dr. Shailendra for inviting me to the conference, and also to Sandeep sir for also inviting me to present in this conference. I'll quickly touch upon the topic of how this emerging debate on new space and how the international space law is being affected and what challenges this new space pose to the international space law framework as such. I'm faculty with Indian Institute of Management, Kozhikode, even though I'm not specifically dealing with space law at present in my teaching part, but my research interest and my doctoral work has been on the space law framework, and it was under Dr. Sandeep sir. So just quickly moving forward, let me actually touch upon the concept of what is the new space. The concept of new space actually encapsulates a loosely understood concept of the increasing commercialization and private participation in the space sector. It actually talks about how the state actors has been withdrawing slowly from the space sector, and it is more thrust or more investments or more specific participation is being coming from the private players or non-state actors. Obviously, this has been due to the result of technological advancements, which actually helps the space sector, non-state actors like SpaceX or other corporates or corporate organization, private corporate organizations to participate in the or invest into the space sector. Obviously, small satellites, the space tourism feasibility coming into picture, as well as the space mining are certain of the important points in this context, which actually comes to the technological advancements which we have seen in the space sector or space faring activities. What is also interesting to note is that when we're talking about this new space from the perspective of commercialization or privatization coming into picture, at the same time, we need to think about how the international space law framework is being developed. The space law framework, as we know, has been developed from a very state or country specific, or what you call as state as an actor in the entire space framework or the spacefaring framework. That is where I think it is important to look at how far the private players or the what you call as private actors or non-state actors can actually be participate and their interest as well as the commercial reality, because the investments which they bring into all these aspects, how far they have been encapsulated in the space law is a question that comes into picture. So I feel there's two challenges importantly to be noted about. One is the aspect of whether the international space law in the present format, is it adequate or not? How far the 5 space conventions or treaties, starting from Outer Space Treaty to the 1979 Moon Agreement, how far they have been adequate to deal with the new challenges that comes into picture. Having noted the fact that the last hard law concept has come into picture in 1979, obviously we have moved leaps and bounds in our technological advancements in the context. So that is where we have to look at the adequacy of space law framework in the international sphere, as well as we have to actually think that what is the best way to go forward for a commercial reality perspective. Can we just stick to the should we stick to the stick to the hard law concept, or should we look at more soft law perspectives or guidelines or global governance mechanisms being developed? So in that context, let me quickly touch upon the question of feasibility part as I raised. I'm just taking the example of the outer space mining issue, even though I think it is already being touched upon, but let me quickly revisit and give a point on that context. So if you look at the Moon Agreement, the common heritage of mankind concept, obviously it poses a major hurdle for the commercial exploitation or exploration aspect of outer space context, especially the mining context, as due to the sharing or the equitable sharing perspective which the common heritage of mankind do bring into. But this aspect of common heritage of mankind being mentioned in the Moon Agreement, I think the countries have largely not accepted it, and I think the state practice also allows us to look at the understanding that it is not a largely accepted concept. And moreover, as we look at new space kind of scenario, we have moved beyond the understanding of a common heritage of mankind situation in the international relations and international sphere. So that is where I think we may have to relook at the way in which we look at the challenges to the international space law from new space. We may have to relook at the hurdles like common heritage of mankind. We may have to look at more practically or pragmatically feasible, commercially feasible mechanisms. So that is where I think there is a necessity that the emerging developments pose on the international framework to come out with international cooperation or a common principles being developed for the purpose of the aspects such as space mining, space tourism, and other such new spacefaring activities. This also is importantly being looked into in the concept or the context where the countries or nations are coming out with their own enabling law mechanisms for space mining. That is something which we have observed in last 5 years. We can actually see that countries such as US has come out with the Space Act or Commercial Space Launch Competence Act, or the Space Resource Exploration and Utilization Act. And Luxembourg also had come out with the 2017 space resource legislation. This legislation enable the space mining or space resource exploitation as such. So that actually takes into consideration that the commercial reality is being accepted at the national level, and it is more important for the international space law framework to actually work in tandem with the new emerging commercial reality of our times. So, in that regard, I think we should look at a global governance mechanism. We already have certain important mechanism at global level, which actually looks at an important international cooperation in the space sector. For example, I think we have the ITU, or International Telecommunication Union, which work on the aspect of the space orbit allocation, especially for geostationary satellite orbits. And we have the interagency debris coordination committee, to which even ISRO is a party, or the Indian Space Research Organization is also a part of that. They actually have come out with an interesting guidelines for space debris mitigation concept. So this kind of mechanism, I think we should look at and see whether there is a possible revamp or possible mechanism of guidelines or soft law or international cooperation being developed. That is the way forward I think I would like to look into in this context. That is where I think I just leave with this thought to all of you, that how India as a country, I think, would be an important player, or important have an important power to actually push for international norm making, especially in the context of space resource allocation, or space resource way in which it has been explored, or exploitation aspect, and space tourism and other aspects being coming into picture. So that is where I think we should take a lead in that context. It would be great to see developing soft law frameworks in that particular scenarios, which are feasible starting points for better international cooperation. So that is where I think, rather than only looking at national legislations, I think it is important to have international guidelines or international common points of reference, even though soft laws, which actually also have an important power to push forward enforcement as well as information sharing, and have a greater role in cooperation agreements as such. So that is my perspective, which I would like to share with all of you. If there is any questions, I'm quite glad to answer that. So thank you for the time and patient listening to all of you. Thank you.
Thank you, sir. And now we'll move on with the question and answer session. And the members have certain questions for you all.
Hi, this is Lakshay. So my question is like open to everyone. Recently, the United States came up with the one small step to protect the Human Heritage in Space Act, which basically protects all the landing sites that previously have been made by the US, and all the hardware that American space missions have on the moon. So isn't it in violation of the Outer Space Treaty, and doesn't it violate the sovereignty principle altogether?
If no one can you hear me? This is Ricky Lee here.
Yes, sir.
Well, it doesn't look like anybody else is going to jump at the question, so I guess I should, if I may. The answer, if I have to reduce it in one word, would be no. And the reason is that if we look at Article 2 of the Outer Space Treaty, it actually doesn't prohibit occupation or exclusive use. What it does prohibit is sovereignty. And and if we go even more specifically at the wording of Article 2 itself, it actually provides for the possibility that property on a celestial body may be occupied exclusively. It says that outer space, including the moon and outer celestial bodies, is not subject to national appropriation by claim of sovereignty, which this is not, by means of use or occupation, or by any other means. In other words, there is a differentiation between the actual physical occupation or use of a part of a celestial body in contrast to an actual legal declaration or the legal effect of actually saying, I assert sovereignty over this area. So there's nothing stopping the US Congress, or for that matter, any other state by executive or legislative action, to use or occupy any part of a celestial body simply through the exercise of the freedoms that are guaranteed to them under Article 1 of the Outer Space Treaty. What they cannot do is to take the next legal step, which is to say, because we use and occupy this area exclusively, it is therefore sovereign state territory. That's what Article 2 prohibits, not the physical occupation, even the exclusive occupation of any particular area of celestial body, but to actually declare or assert sovereignty over any such area, regardless of whether they occupy it or not.
Yeah, that's completely correct. And if I could just add on a little bit to that. So I think, as you know, there's more and more private sector activity taking place in space. And so one of the things that we at UNIDRA have been looking at is how private parties can have interest in objects on celestial bodies. And it is completely correct in mentioning that while it's true that you can't really land, so you can't really say you own part of the land of a celestial body, you certainly can.
Sorry, Hamza, we can't hear you. We can't hear you because your speakers are providing feedback. Can you please just mute your speakers?
My apologies, is that better?
Much better, thank
Yes,
you.
sir. Yes, sir.
Right, my apologies. Now, I was just saying that I completely agree with Dr. Lee, and I think this is one of the areas that we at UNIDRA have been looking at quite a lot as to how ownership rights and interests work on different celestial bodies. And he's completely right to mention that while it's true that you can't really lay sovereignty or claim the land a particular object on a celestial body is located, but you can certainly have an interest or a right on an object. So sovereignty applies to the land rather than objects on the land. And the Outer Space Treaty and the other space agreements certainly do provide for states to protect their own work in space, including to the extent setting up scientific camps and putting areas in which they're working in, and there are provisions accordingly. So yeah, I completely agree with Dr. Lee. Thanks.
Okay, if I have to intervene, I should say that the debate is primarily with respect to last aspect of Article 2 of the Outer Space Treaty. Because the Article 2 says that there shall not be any national appropriation by claim of sovereignty, by use or occupation, or by any other means. So sovereignty, use or occupation, all of them would not come within the ambit of actually the current scenario where actually the United States has passed the law. But whereas the last limb, is there any actually national appropriation by any other means? That is something actually which has been debated primarily. But again, I should say, I mean, I would agree with Professor Ricky Lee as well as actually Hamza with respect to this, because we have to read Article 2 in light of Article 1. Wherein Article 1 says that everyone would be having the freedom of use, exploration, and scientific investigation in outer space and celestial bodies. There is a freedom to do all these things. And in the process of that, if there is a requirement for actually creating the protective zone, or if there's a requirement of actually facilitating that kind of activities in the outer space, the states can very well do that. So therefore, we can't read Article 2 in isolation. We have to also come back to Article 1. So to my understanding, such a safety zone can be created, that is possible, but it has to be ensured that they're not going to claim any kind of exclusive right. They're not going to say that that's their sovereign territory. All those kind of claims, they should not do it. As of now, the United States, in all probability, is not going to do that. That's what is my observation.
Thank you, sir. Thank you so much.
So the next question would be, how can space tourism be used for used to develop foreign relations? If you could answer.
I don't think there is any relationship between the space tourism and foreign relations, especially because it would be more of a private tourism actually. So I don't know how far actually it's going to build the foreign relations as a. We may have foreign investments, that may be possible, but I don't think it's going to influence the foreign relation in any way. I mean, others can supplement that if anyone else is having any.
I think I would just add, I think that that's completely correct, but I think a lot of how much influence space tourism will have on foreign relations sort of depends on this question that I think one of the colleagues explored in their discussion as to whether space tourists can actually be regarded as envoys of humankind, right? So if you do sort of come to a conclusion, which I don't think the international community will come to, that space tourists are envoys of humankind and do fall subject to the rescue agreement, then there might be some scope for bettering international cooperation and international relations. But besides that, I do think it'll largely be private sector activity, and I think Attila might have views on this, but it'll just be like an airline going to space and coming back. So yeah.
I just would like to add something. Charles Simonyi went to the outer space twice as a space tourism, the tourist person. It is a Hungarian fellow living in the United States. It's a very rich man, and just in terms of public relation, he was just during his mission, twice missions, he just read poems, Hungarian poems, listen in the radio, Hungarian radio. So that will be a lot of cultural impact of that. So I don't see it's a legal issue, but it is a lot of cultural and educational prospect behind it.
If I may, oh, by the way, I apologize for not turning my camera on, but my new puppy had jumped onto my desk and decided that it looked like a tennis ball and took my camera away. So, because I have been concentrating on your presentations, I haven't gone to wrestle it back from my dog. So I do apologize for not showing my video. I take a slightly different tact. I think the two general concepts of space tourism and foreign relations don't really have an overlap. I think that's right. But that presumes that even on a terrestrial level, there is no correlation between tourism and foreign relations, but of course there is. There are tourism and this money, the economic power that is exercised by tourists of certain countries by allowing their citizens to travel to different countries is a matter of trade and foreign relations. The most prominent example of that is China. If your country is on the list of approved destinations for Chinese tourists, then Chinese people will travel to it. But if your country is not on China's preferred tourist destinations, then Chinese tourists will not go there. So in that context, even on Earth, leaving aside the issue of space tourism, is there a correlation between tourism and international relations? Yes, not a great extent, but yes, of course there is. And since, as far as space tourism is concerned, any space installation, be it a hotel, be it a spa, be it a beauty salon, or whatever it may be that is in orbit, the whichever member state that has it registered on their state registry maintains jurisdiction and control over it. By extension, if for the sake of argument, if Australia is not on the list of preferred tourist destinations for Chinese citizens, which currently it is not, then an Australian hotel in orbit would equally be not a unpreferred destination for Chinese tourists. So I think you would look at it as a general principle. Is there a correlation between space tourism and international relations? Probably not. But is there a correlation between domestic tourism and international relations? Well, yes, there is. Then by extension, there would be some implication of that in orbit.
Thank you, sir. The last question would be, is foreign tourism, is space tourism really possible because it requires a lot of funds?
I think if I may jump in and then I'll let the others chime in. I think if the past sort of 10 to 15 years have proven anything, and I think this was really outlined in Dr. Prasad's presentation with the whole advent of the new space sector, there is a lot of money available for space activities, but at the same time, the amount of money necessary or required to access space has also drastically fallen. So back in the 60s and the 70s, or even in the 80s, when it used to take tens of thousands of dollars to transport 1 kilogram into space, now SpaceX is doing that for 1 to 2,000 kilograms. And the cost of access to space is falling drastically, whereas at the same time, interest in access to space is growing exponentially. There are people out there that are looking to book flights on spacecraft and have those experiences. So while I do understand that it is indeed a very costly idea right now, but there is certainly a lot of developments in the industry that will provide for it, in my opinion. And in the next 15 to 20 years, we do see a lot of funding flowing into the space sector through various different mechanisms, and we certainly hope asset-based financing is one of them. But regardless of that, personally, I do think that the space tourism sector is bound to grow, and then there will be space tourism in the future. Yeah, thank you.
Okay, so just to supplement, probably I can draw the analogy from the aviation sector. So the best example maybe in India itself. So till the beginning of the 21st century, aviation was a kind of a luxury for common people. Right? Very few people used to actually fly. And as we know, after the 2003, after the entry of the air Deccan into the Indian market, there has been a drastic change in the aviation sector, and it has become affordable for everyone. Right? It is on the basis of technological development. So I'm sure that actually in the space sector also this is going to happen. And as the time passes on, of course, it might not be like, say, everyone would be able to have access to the space. I'm not promising that. But what I'm saying is that at least actually some section of the society would definitely be able to afford the space ventures. They would be able to get on the space tours. Thank you.
If I may jump in again, and I promise I will not answer the next question. I actually see on some level that space tourism, looking at the economics of space tourism in itself is actually looking at the cart before the horse. Because if anything, space tourism is actually a necessary byproduct of something else. As Richard Branson admitted a few years ago, the reason why Virgin Galactic was so interested in Spaceship One and building Spaceship Two is because they see a very lucrative future in suborbital point-to-point transport from different points of the Earth. If you were to say that if you could travel from Sydney to New York in the time of 2.5 hours, because you're going through suborbital space, there would be a substantial market for that. It actually takes less than 2.5 hours for an average missile, but unlike a missile, this thing actually has to slow down and stop and for you to get off in one piece, without spilling your food and alcohol. So that's why it takes 2.5 hours. But assuming for the moment that that is the long-term plan, the idea is to build small suborbital spacecraft that can go from A to B on Earth in an extremely short period of time. Then, as Attila will tell you, the amount of test flights that are required for a new civilian aircraft to enter into service and obtain airworthiness certificates, it is in the hundreds. And so the Virgin Galactic model is that, well, we know that when Spaceship Two is built, we need to have at least 100 test flights. So instead of not being able to make a single dollar out of that, if we were to sell seats for $100,000 on each of these test flights per seat, we would be making money on test flights of a brand new civilian aircraft that we otherwise would not have been able to make money out of. So in that sense, the economics of space tourism is inverted. Rather than it being a cost of the tourism itself, it is actually a profit, a revenue in the testing of a civilian aircraft that they want to enter, or spacecraft that they wish to enter into service in the future. In that case, the underlying cost is not so much the issue. It's more the question of how much can you get away with charging somebody to be a crash test dummy on your experimental spacecraft.
Fully agree. Just look at the automobile industry, and Mitsubishi has got also aerospace industry department. So it is everything connected one another, and you are absolutely right in this regard. Actually, this year, Richard Branson announced that it will be the first flight, which will be a real one, and bringing those people who paid that amount of money to the outer space.
Thank you, sir. We all thank you for such great insights. This would be the end of question and answer session. The next session starts at 1:30. You may join by 1:15 or stay in the meeting itself. Thank you.
Thanks, everyone. Bye.
Thank you.
Thank you, everybody. Thanks so much.
Thanks to everyone.